Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we have the rest of Monica Rial and Ron Toye's response to Vic Mignogna's appeal of Judge Chupp's catastrophe. I apologize for being late. I never will apologize for being gay. Late and gay. These days, how would Drexel word it? Or more importantly, Drexel's dad, I guess. These damn kids. These kids, man. Drive me into an early grave. Oh boy. So I hope you all enjoyed Ronversations last night. It's always a pleasure to talk to Ron and bring that to you guys. Really great. Have you been DMing me? I haven't even opened Discord really today, Brawley. Sorry, buddy. I will look into it. Siren Jack, I barely did anything about anything today. I was working outside. Working for the man. No, it was a really, really phenomenally nice day out. It was 64 degrees. It was sunny. It was calm, peaceful, and I spent a good amount of time outside. It's Minnesota and it's still too early in the year to get a tan, so sorry. The albedo coming off of my face isn't changing anytime soon. But it was nice. It was nice to be out for a bit. That said, you know, that took up a good chunk of the day. All right. Preview for the week. Reminders. Today is this. Tomorrow is Human Sunbeam Ethan Van Sciver, who just had a pretty interesting conversation with Donnie Cates. Donnie Cates. I don't know anything about these comic book people, but apparently Donnie Cates is maybe a Marvel writer or something and doesn't understand what hey, I'll talk to you tomorrow in private means, but I can't right now because I'm on a live stream. Like the amount of weird stuff that people lay at the feet of other people is it's disconcerting. I will tell you without details. I can't give you details on this. It wasn't Ron, but someone reached out to me after my stream yesterday, right? Ronversations 10. And they yelled at me about something Ron said. Like, what the hell is that? I didn't say it. They were mad. They're mad that I shared what Ron said because they were mad at the thing that was said. And that now someone else saw it. I don't know. It wasn't even important. It was completely innocuous too. It wasn't like anything bad. But they were mad at me. It's like, so I watched the clip from Ethan's show, and Donnie calls in, and Ethan's like, "Hey, Donnie, I'm live on the air, and so are you with 2,000 people. You know, I'll talk to you tomorrow, but you're live right now. If you just want to say hi." And then he's like breaking Ethan's balls over having him on the air. And he's like, I'm trying to talk to you. He's like, I just wanted to have a private conversation. He's like, I know. Let's have it tomorrow. Just getting mad at him for that. This is, I read something Ron said that, and the funny thing is, again, I wish I could tell you what, but imagine the ass chewing I would get for mentioning what it was when I didn't even, you guys don't even care about it. That's the funny thing. Like, I don't, well, maybe you do. I don't know. I don't know you personally. I don't know your wants and desires, but nobody's ever clamoring for the information. Like, nobody's ever messaging me and say, hey, what about this thing? No, it's something so unimportant to most people that I encounter. And so I'm like, why are you yelling at me? Yell at Ron. Like, go yell at Ron. I don't care. But they expected me to not share the entirety of the conversation because of the one throwaway thing Ron said about it. Well, what the hell am I supposed to do? So anyway, dealing with too many drama queens, man. Oh boy. Will there be more conversations? Look, if Ron talks to me, I answer. That's the best. That is the best answer I can give you. If Ron talks to me, I answer. Of course. What else am I going to do? I'm on quarantine. But anyway. So that's that, y'all. Tomorrow is the Human Sunbeam. Looking forward to talking about Wrecked Planet. Guy has like 12 Indiegogo projects out right now, or whatever. So he's just, I don't know what he's doing. He's got a whole bunch of them. I want to talk about it, but I mainly want to talk about what's going on in the comics industry with coronavirus, and also, Wrecked Planet. That's his big one, and then of course, this Donny Cates thing, and is new. I don't know the context. Something about Nazis. And then finally, I want to talk to him about some recent threats of violence that he may have received by text message or by Facebook message or messenger or something. And I'll tell you, I read through those. In my state, those could be charged as felonies. Like if I were to send that threat to someone, they pass muster as an actionable threat. Now, did he mean to threaten Ethan? I mean, an attorney with a penchant for a conviction would say yes. I don't know if he actually did or not. But yeah, I mean, they're real threats. Like, one was like, blow your face off or something. And he didn't mean like suck it. I think he mentioned a gun, something like that. And then there was another one about punching him squarely in the face. Those are pretty interesting, And Ethan took it in stride. He's just like, whatever, man, just chill out. I care about you. I care for you, and he's playing really nice. But yeah, I mean, people need to be careful because it's not always, it depends on the state. It's not always up to the victim. A state's attorney in Minnesota, for example, I'll probably do a short video on this because it's interesting to me. But in Minnesota, a state attorney sees those texts, those messages online, and knows that they were sent in Minnesota or sent to Minnesota. They don't need your help to initiate the charges. They could file them. Now, it'd be tough without cooperation of some sort. But, an attorney goes up, sends a subpoena to Ethan, says, hey, turn over the messages from this person. Are you going to resist the subpoena? I mean, that takes time and money. I just turn it over. Here you go. Yeah, here's this weirdo threatened to kill me. And they could make a case. They can make a case off of that. They don't actually need Ethan to report the crime. Now, they probably won't, right? There's not just like a random state's attorney in New Jersey or wherever the other guy's from, like, watch this Ethan Van Sciver show and see if there's any crimes out here. Like, that's unlikely. But I'm just saying it's possible. And so you got to be careful what you send to people, because there aren't a lot of words that are actionable, but there are some, and those might actually fall into it. All right. Thursday, looking like a Drex stream. I think it's pretty much confirmed by now. Drexel show on Thursday. I gotta return some emails and see if people are available for Cut College. And then Friday, Big Brain Panel. So, and again, that'll be Mr. Josh, Mr. Peacock, Mr. Steven, and Mr. Ty Beard guest paneling with us. So that is that's the layout for this week. Yeah. Let's get into the document here, and we'll see how it goes. There's a lot left. I don't want to stall too long. Barocco Gaia says, "Hey Nick, just celebrated 10 months of weight loss. Lost 134 pounds. Thanks for the abdominal exercise with laughter. Really adds to calories lost. 33 pounds to go until at ideal weight." Buddy, 134 pounds? You lost one Ron or 1/8 of a Monica. It's amazing. That is awesome, dude. Cheers, my man. Good job. Keep it up. Keep it up. Murnum 007 says, "Hey there, Nick. Pour one out for my husband who works at a kidney dialysis clinic. Both he and I were able to keep our jobs, but he's more vulnerable than I. He has an 18-hour workday ahead of him tomorrow." Oh, God. Rip. I mean, he's not dead, so it's a weird rip, but that sucks. 18-hour workdays are rough. So my best to him. Hopefully he stays safe. Wear the coof masks or whatever. And stay healthy. Stay healthy. Oh, goodness gracious. This is for him and you, please. I've been drinking the Calumet Farms, which is a good bourbon. Fine. I've been drinking the Bareface whiskey, which is a good, really neutral whiskey. One of the better, if not the best, Canadian whiskeys I've had. I've been drinking the Beat vodka, which is just, it's the clear liquid at the bottom of a garbage can. But man, when you take a sip of Highland Park and it's been a little while since you've had something good, whoo! Invigorating and refreshing. Just delicious. Okay, and then at Zuma99 says, "Ron was projecting to a whole new level in that last stream. Finally got to see the little weasel crack at the end. It was funny. Also, I sent you a DM on Twitter. You should read it when you get the time." I will check it out, buddy. All right. Let me get things organized, situated here. Where are we? That's John Volney. That is John Volney. All right, where were we? Oh, God. I remember where we were. We had just finished the summary of facts, and we were moving to the summary of argument. Right? I think that's where we were. Yeah. Okay. Oh, no. We read the summary of argument. We're on arguments and authorities. That's where we were. Okay. Now we got it. Sorry. Had to go back into my brain for a minute there. Always a scary thing. Here we go. Guys, Ron Toye did Vic a little bit of a favor. He raised a good amount of money for Vic yesterday. We are within striking distance of $280,000, and I'm not. This isn't a call or anything like that. I'm just making a status update. Again, I'm trying not to really push the GoFundMe too much. I brought it up a couple times last stream because of Ron. Ron, talking about how I am the anonymous donations. It's true. It's all true. I'm definitely the anonymous donations because it's not against GoFundMe's terms of service to self-donate and to inflate the amount. And it's certainly within my best interest to take money that you guys would give to me, minus 30%, and then put that into a GoFundMe. That is exactly what a normal, rational person would do, and that is how I keep the grift alive, by giving the money to someone else. Best plan, top shelf plan, but that's what's going on. So Ron helped out there. There have been some donations since the last show, and I want to get to those. Here's where we stopped. Oh, thank you to Anonymous Patrick, which is me. Thank me. Patrick Hogan, Richolas Nikeda, a nefarious person if I've ever heard of one. Mike F, press F. Ron's Remote, Anonymous and Anonymous, also me. Fleming Grove Scovengard, CCP Virus. Come on now. Heather Harrison, Anonymous and Anonymous, you're welcome. T.S. Grady and Jason Camion. Thank you to all of you for donating. I just heard my door open, but I don't see any little rugrats running. What is going on? But thank you all for your generous donations. Raised somewhere around like hello? Oh no, just a second. This will take just a moment. To bring Ron's face in. Was that song from Annie? Little girls, or whatever? Oh my goodness. Okay. So anyway, thank you all for that. But yeah, raised like close to $1,000 from the start of last night's show. So awesome. Very much appreciated as always. Okay, back to this. Oh, do I have any comments on the Fantasy Soft situation? Yeah, pretty simple. If you saw Vic's Unlocked stream, it looks like what was going on was this. Fantasy Soft said years ago, "Hey Vic, we would like to do a show about Christian furries." And Vic was like, "Christian furries? I love Christian furries. I'll do a show about Christian furries. When you get it set up, let me know. We can talk about it." And then what they did was last year, when all this started, they said, "Hey, we're still having Vic for our show. Please fund it." And it looks like they didn't ever solidify an agreement with Vic or have any right to use his name or image in association with their product. Interestingly, okay, you guys are coming up with short video content for me left and right. I've been having trouble thinking of short videos to do lately, which is why there haven't been any. But I'll do a short one on this too to really shore it up. But there's an invasion of privacy tort, which is actually more like an invasion of publicity tort. And it's a false advertisement, sort of. It's where you say someone is endorsing a product, but they're not actually doing it. That's a legal cause of action, because you're not just putting someone's image somewhere. You're putting someone's image or voice or whatever to the idea that they're actively endorsing the product that you're selling, which that's taking something that is a commodity of theirs, right? The commerciability of their endorsement, and you're putting it on there. So like, if technically speaking, if someone out there created a product and then said, put a clip of me endorsing the product without my permission, that would be an unlawful use of my image, because I can certainly monetize an endorsement. And so if you did an endorsement without consulting me, then I could sue for the value of that monetization. That's damaging to my reputation, especially depending on the product. It could be more so. So it's actually an unlawful act. It could be remedied in court as a civil tort. I'm not that this would be or will be or anything like that. It looks like it's resolved now. But it kind of looks like they were without Vic's permission, saying that Vic was endorsing their anime and was definitely going to be in it, even though it looks like no contracts were signed. So, unfortunately, a lot of people gave money to FantasySoft for that. Hopefully, for everybody involved, that money was either returned or they got something out of it. I heard they had a Patreon and like a webcomic or something. So maybe people got value out of the thing they were producing. It's really too bad. It's really too bad to do that. You don't want to do that. So, that's the way it goes. And now before the big brain comparison comes, from Law Twitter or anywhere else. Yes, I started the GoFundMe, without Vic's permission or whatever. So did someone else, by the way. Started a GoFundMe. I think they ended up folding it into mine or something. I don't remember. It doesn't matter. Before the obvious comparison, the way GoFundMe works, had Vic never ever taken the steps to accept the money through Ty, right? Had that not ever occurred, the money would have been refunded by GoFundMe. It never came to me. There was no way to actually promote and take money away from someone for that thing. GoFundMe holds the funds until they get verification of the third party that is going to be receiving the funds. So before there's some weird comparison, also wasn't selling a product. And I think the amount of time between me opening the GoFundMe and Vic making a public statement about it was a matter of like 18 or 20 hours or something like that. So, anyway, that being said, just so there's some clarification there on what would have happened if Vic had said, no, never, GoFundMe would have just given the money back. I mean, I also would have shut it down immediately, but anyway, Monley, yes, it's on right now. This document on screen is MoRon's appeal response. So, here we go. So, arguments and authorities, the anti-SLAPP legal standard. Chapter 27 of the Texas Civil Practice and Remedies Code seeks to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, and at the same time protect the rights of a person to file meritorious lawsuits for demonstrable injury. It does so by establishing a mechanism for early dismissal of lawsuits that threaten the right of free speech, right to petition, or right of association. statute is to be construed liberally to effectuate its purpose and intent fully. The TCPA defines the exercise of the right. Notice what a lot of people are doing. A lot of the people are doing is, in these things, is they're leaving out what the purpose and intent is. And they're doing that for a good reason, because the purpose of it and intent. Now, to Funimation's credit, I'm pretty sure they put it in there. But the purpose and intent is to also allow the just outcome of meritorious lawsuits. You need to go to bed. Go to bed. Go to bed and go to sleep. Where'd you put it? You had it. Go. Go to bed now. Oh boy. Quarantine is great. Except that kids just won't go to bed. I wanna address one last thing with the fantasy soft thing. Someone had mentioned that it's possible to do a contract that's contingent upon funding. Sure, yeah, it is. No indication that occurred. That's part of the problem. Is that it? According to Vic's Unlocked stream today, which has been uploaded by Emish on Twitter, or at least parts of it, Vic did not appear to have given them permission to run with that. He said he did not want his face used for his name and stuff used for fundraising on the project, and that they were to come to him after the project was funded. So. Ugh. Anyway, back to this. The TCPA. Oh wait, sorry. Yusuf 343 Jasmine 343 says, "Hey Nick, I love how they spout about this is the truth. This is truth, but no charges, reports, or arrest was ever made against Vic, even until now. All this truth is in a defamation case and not a criminal case." Yep. Well, they couldn't go to criminal court with any of the stuff that even the stuff that they think they have. They would get thrown out in a heartbeat. All right. TCPA defines the exercise of the right of association to mean a communication among individuals who join together to collectively express, promote, pursue, or defend common interests. Which is weird because that's a right of association until it's to commit a tort. Then it's part of the element of conspiracy. Joining together to collectively express, promote, pursue, or defend common interests in tort. If it's a tortious act, then that would be part of civil conspiracy. But that's what the right of association is, right? It's the right to do everything together up until you violate someone else's rights. Then it's no longer a tort. But that's pretty funny. It goes on to define exercise of the right of free speech to mean any communication made in connection with a matter of public concern, which includes any communication related to health or safety, community well-being, and a public figure. There's no requirement that the communications themselves be public. Rather, the communication must simply relate to health and safety, community well-being, or a public figure, stating that protection of children from abuse is of the utmost importance in Texas. Now, notice they weren't really talking about protecting people from abuse. So that's I know that's what they're trying to invoke here, but that's not what they were doing. Lathan says, first time super chat. Hey, thank you. Love the show. Here's some money to help pay Chair Coon's salary. Well, slave wages up in here, Corona Chan and all. The TCPA does not require that the statement specifically mention health, safety, environmental, or economic concerns, nor does it require more than a tangential relationship to the same. Rather, TCPA applicability requires only the defendant's statements are in connection with issues related to health, safety, environmental, economic, or other identified matters of public concern chosen by the legislature. Now, again, what's interesting about this is where you go from the text of the law and the intent being likely different. Now, to be clear, the interpretation of the TCPA here is, this is the status of the law. It's correct. And likely the TCPA does apply. Their argument over the TCPA applying is largely pro forma. They have to make it. But I think the TCPA probably does apply at the end of the day. I've never been much in doubt about it. Now, what Vic's side appears to be arguing, and the argument will be up to the court, obviously, is that the TCPA might apply, but they didn't provide enough evidence to make it apply, and that's their initial burden, and they didn't meet it because Judge Chupp should have stricken their evidence. Okay, I get the argument. And that's what they're trying to do in reverse. Vic didn't provide enough evidence, blah, 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 blah. In an ideal world where everything is perfectly included or whatever, I think the TCPA probably does end up applying to the case. Now, whether or not it should be remanded because they didn't present it adequately, that'll be up to the court. But I don't think there's any question that the TCPA seems to apply in this case. It's been an expected motion from the get-go. So the legal question of whether appellees established by a preponderance of evidence that the challenged causes of action are covered under TCPA is reviewed de novo. This court also reviews de novo's trial court's determination of whether a non-movement presented clear and specific evidence establishing a prima facie case for each essential element of the challenge claims. Finally, the plain language of Section 27.009A1 mandates that successful movements for dismissal under TCPA are entitled to an award of reasonable attorney's fees and other expenses incurred defending the action. Importantly, the statute does not afford discretion to award no attorney's fees and other expenses when the amount is supported by record evidence. Now, interestingly, they didn't award no attorney's fees or other expenses. So this is a weird thing to say that it's important. The attorney's fees and other expenses have been awarded. It's a matter of reasonableness. What Judge Chupp or the trial court found to be reasonable or not. Not whether or not he awarded them at all. He clearly did. So, there you go. Rial and Toya's response to appellant's issues on appeal. Issue 1. The trial court properly found that Rial and Toya established by preponderance of the evidence that Mignana's claims are based on, relate to, or in response to appellate's exercise of their right to free speech and right of association. Okay. Mignana's brief barely mentions step 1 of the TCPA analysis, presumably because his petition together with the evidence and affidavit show unequivocally that he sued appellees for engaging in 2 prongs of protected communications, the right to associate and speak freely. When it's clear from the appellant's pleadings that the actions covered by the act, the defendant need show no more. That's Hirsch versus Tatum. Mignana sued appellees for allegedly joining together and communicating with one and others to collectively express opinions about him, a public figure on the internet. C. Weber versus Fernandez, finding that statements contained in Facebook messages and postings are communications as defined by the TCPA. Which is... Never mind. And then Smith versus Crestview, explaining that the breadth of the TCPA's definition of communication extends the application of the TCPA to almost every imaginable form of communication in any medium. The October 4th dismissal order properly granted appellee's anti-slap motion because appellees showed by a preponderance of the evidence that the claims relate to or in response to appellee's right of association or free speech as defined by the statute. Now again, I think they're largely correct that the TCPA does apply. What I think they should do is point out that in their pleadings, They are suing for them joining together and communicating with one another, and that they have stated that that is their right to do so, and they've done so, and that is part of the conspiracy issue. I mean, you might as well. Always use your opponent's arguments to your advantage when you can. Now, again, we didn't come together to say stuff. We just came together to say stuff. Well, I mean, okay. Mignon is a public figure and inserted himself into a public debate about his sexual harassment of minors and women. Here's those apologies. They're coming back. They're going to come back. Hold on. Mignogna never actually denies that he is a public figure in his brief to this court. In fact, he admitted that he's been in movies, been on television, voice acted for hundreds of Japanese anime films, and attends conventions where thousands of people show up. Instead of disputing his public figure status, Mignogna's brief simply argues one time that because the trial court failed to sustain Vic's objections, the trial court's findings that Vic is a public figure and that Monica and Ronald's tweets related to a public controversy are based on inadmissible evidence. I do think that it's nice that they bring this up, and they should address it in the reply. That they should maybe flesh out that argument a little bit more. I don't know if they will or not. It depends on how much investment they're going to put into that argument. But you know, if they are pointing out a deficiency here, then go ahead and bolster it as a response. However, not only does Mignogna fail to identify and articulate his objections, I mean, that's not true. The objections were actually filed by the court, or to the court, in a document, in a prolonged document. He also failed to obtain a ruling on his objections in the trial court and never sent a Trap 33 letter, thus waiving any objection to his public figure status. That's not actually true. He received a ruling. He received a ruling to his objections prior to the trial court. It was actually filed with the court. So this is a weird statement because there was a ruling on this issue. There was a ruling to it. They objected to it in a motion to strike. That motion was denied by Chup specifically. And there you go. They obtained a ruling. Not sure why. I mean, I would cram that down their throats. They're misrepresenting what happened. It's flatly in the record. Regardless, the evidence pointing to Mignogna's status as a general purpose public figure is overwhelming. Mignogna's own petition states that he's a well-known voice and on-screen actor who appears in 35 to 40 conventions per year to sign autographs and take photos with fans. Mignogna has also amassed 113,000 Twitter followers and has a dedicated fan club for over a decade. Had a fanboy. Oh, that's me. Raised more than $257,000 to fund this lawsuit. Well. I guess it's time to mention the GoFundMe again. Oh, there we go. We're at $279,038. Thank you to David Vaughan, Roger Bjornrud, Anonymous Notnick, Anonymous, Damian Sawyer Hammond, and Jason Kyman I already mentioned, but thank you again, Jason. So there you go. We're over 279,000 by a fanboy, which is flatly untrue. I am not a fanboy of Vic. Where are we? This one? Yeah. Again, at the time I opened the GoFundMe, I barely knew the guy's name. Barely knew him. I liked the character Broly 20 years ago or whatever, and then had no idea who ever voiced him or played him. Actually, even funnier. The Broly that I was familiar with was not Vic at all. I liked the character Broly, but I was always watching clips of Broly in not English, either Japanese or like French or something. Whatever was on various websites where I could see a clip of a Broly movie. That was it was not like I was super into this voice actor. Never even heard of Star Trek Continues until all this started. So, you know, it's just not true. But reversing denial of TCPA motion to dismiss and barring defamation claim where the plaintiff was a limited purpose public figure. Okay. There are two types of public figures: general purpose public figures who achieved such pervasive fame or notoriety that they become public figures for all purposes and in all contexts. And then they're going to argue that, well, in the anime community, all purposes in all contexts, such pervasive fame or notoriety for all purposes and in all contexts. And then they're going to argue the context of the anime community as justification for him being a general purpose public figure. Okay, sure. Limited purpose public figures whose status arises for a limited range of issues surrounding a particular public controversy. And that anime is not a public controversy. Even if Mignogna's fame and notoriety were not enough to make him a general purpose public figure, spoiler alert, they're not, he publicly intervened and addressed the controversy here on at least 5 separate occasions. Here it comes. Can't ever apologize. Making him a limited purpose public figure for purpose of Appellee's anti-slap motion. Aside from his general fame, Mignogna publicly inserted himself into the online Twitter war. 1, hosting a pre-apology chat with his fan group to stir them up to defend him. That's a weak one. That's a weak one. Addressing something to a private fan group, and this is them saying, you know, it's a fan group. Addressing your fans and saying, hey, this isn't true, isn't inserting yourself into the public controversy. The next one, making 2 public apologies to his 13,000 Twitter followers. I would go ahead and, I don't know, they got to mention that he didn't have 13,000 Twitter followers. But that being said, yeah, we're assuming facts, not an evidence. That being said, can't do it. Can't do it. Publicly supporting the GoFundMe campaign. This is absolutely not. This is not. Not at all. Can this make him a public figure? This isn't actually hey, this is legitimate, by the way, is not an endorsement of any sort of action or call to action or insertion into the public controversy at all. By the way, some guy set up a fund for legal defense for me. And yeah, that, no. Asking his fan club to do whatever you can to counter all these lies and negativity. Now, this is interesting. This and this were the same instance. These are the exact same thing. And notice they're citing to the record at 687 here and 687 here. So they've actually lied to the court and misrepresented that there were 2 separate instances when it's the same instance they're talking about. And then providing commentary for at least 1 magazine during the controversy. Oh, there you go. Responding to allegations raised by someone else. One of the defendants being an anonymous contributor to that thing. Don't talk to the media. Unless you're going to go full out. If you're going to go full out, like, you go hard. Go hard. Make them taste the short and curlies. And you go all in on the media. Never half-ass it. Father of arrested child became limited purpose public figure by inviting press and public attention on several occasions and in several different ways during the course of public debate. So let's do something here. Eliminate 4 because 4 is the same as 1. And then we eliminate 3 because it's nonsensical. And you've got 2 public apologies and a pre-apology chat to a small group of people that are not in the controversy to stir them up to defend him is actually, again, assuming facts, not in evidence. It's a factual question that the court did not actually address and should fall in favor of Vic, which I'm pretty sure he said that's not what happened at all. That's not what he was doing. That was not his intent. they should argue against this because they have not. This is not enough to make him a limited purpose public figure. If he's not a general purpose public figure, this isn't actually sufficient to make him a limited purpose public figure. And if they can do that, they can take away one of the 3 prongs of the anti-slap even applying. In my opinion, they should dedicate some word count to this because by a preponderance of the evidence, they didn't actually show that he was stirring them up to defend him. He said, go out there and be positive. And then they're taking that out of context and saying, do whatever you can to counter all these lies and negativity. Notice there's not a period here. There's not ellipses on either side of this. This is misrepresenting that statement because he, if I remember right, actually said, go out there and tell people positive stories. That's it. Just share positive experiences. That's not inserting yourself into the public debate about it at all. But make them earn that. Make the trial court or the appeals court at least ask the question because those factual matters may fall in favor of Vic. They're supposed to. Doesn't mean they will because it's people. But make the argument. Make the argument. And also, just so we're clear, the defendants were doing this. The defendants participated in that magazine during the controversy, or at least one of them did. And defendants, by their actions, cannot make a plaintiff a public figure. A defendant engaging a plaintiff and eliciting some sort of response doesn't automatically make them a public figure. So you can't generate a controversy on someone and then they're suddenly a public figure because they're in it. So I would spend some words arguing it. If they can defeat the public figure status, then they go a long way towards getting part of this or all of it turned back because it puts a big wrench in their plans. Rick Rekieta says, first time super chat. That's not true, but thank you. You're a heathen who puts ketchup on hot dogs and mayo and pickle relish. Just the cheap Heinz sweet relish. Go do something reckless and dangerous in Minecraft. Bourbon is better than scotch. Deal with it. This scotch is better than this bourbon. Just so we're clear. Just so we're clear. All right. Mignogna's claims relate to Appellee's right of association. On their face, Mignogna's claims implicate Appellee's right of association because they arise out of communications among a group of people who publicly commented on the serious allegations against Mignogna, as well as the threat he poses to female fans and convention attendees. Appellees have the right to associate amongst themselves and communicate with others who have experienced Mignogna's abuse and inappropriate behavior, and to communicate about those common interests within the larger community. Even in this court's decision in Kawak versus Antero Resources Corporation, and the Dallas Court of Appeals decision in Dyer versus Medoc Health Services, require applying TCPA to Mignogna's claims and dismissing them. Kawak and Dyer opinions held that the right of association's common interests must be shared by a group of more than two and involve some form of public participation. Those elements are met here because the gravamen of Mignogna's allegations is that Toye and Rial joined together with Markey and Funimation agents, employees, or business partners to collectively make Twitter posts go viral by retweeting them and telling the world about Mignogna's indiscretions. There you go. According to Mignogna, Jamie, Monica... So here, again, this is an element of conspiracy. They're stating it flat out. Remember, they said that he didn't meet any of the elements of anything, but in his complaint, which they're citing to, there's an element right there. According to Mignogna, Jamie, Markey, or Monica, Ronald, or other Funimation employees or business partners urged anime conventions and other studios to terminate their contracts with Mignogna, telling some that Funimation was conducting an investigation into allegations that Mignogna was a sexual predator. Not only are those statements literally true, but Mignogna admits that the statements arose out of public comments made online by a collective group. Communications between... now this is... What they're saying are the statements here that Mignogna is a sexual predator. I'd go ahead and argue that, yes, All of these statements are literally true. They just admitted to it in their brief. Yeah, these statements are literally true. Jamie, Monica, Ronald, and other Funimation employees or business partners urged anime conventions and other studios to terminate their contracts with Manana, telling some that Funimation was conducting an investigation into allegations that Manana was a sexual predator. Here you go. Not only are those statements literally true, respond and say, damn right they're literally true. There you go. There's the prima facie right there. Right there. But Manana admits that the statements arose out of public comments made online by a collective group. Okay. Not only are those statements literally true. Now, I don't think they mean the whole statement. They mean these things, but they're not clear at all. They should just go ahead and argue it. Of course they mean all those. Of course this statement that they just said is literally true. All of it. Everything in the quotes. Communications between Real Toei Marquis Denbo and countless Twitter users were not private communications. Really? Really? That's interesting. Here's a lie, flat out. 10 is, Manana now argues for the first time on appeal that the TCPA does not apply to his conspiracy claim because the public comments on Twitter are actually public comments about private matters and therefore not the subject of the TCPA. This argument is both waived and unavailing for reasons explained throughout this brief. Except, this is dumb. Why did they add Denbo? Denbo made no public statements about this and specifically told Vic that this was a private matter. And that's in the record. That's in the record. So again, we've got a real issue here that they should flush out. Communications between, they're conflating communications. The communications Real Toei, Marquis, Denbo, and countless Twitter users were not private communications, except only the private ones were private. The ones that they actually said were private. They said it. They told Vic that it would be private. That's a central part of the claim. Felipe Mube says, hey, Nick, first super chat. Thanks, Felipe. I don't really know who Vic is yet. I know he's kind of gay and old. That's it. Still will support him versus the crazies. Yeah, absolutely. Thank you. So, a weird inclusion of Denbo here. Again, I would use it. Use it. Denbo specifically labeled these, or said that these communications are private, and they have never, ever produced anything public from Tammy Denbo, except for her affidavit as part of this lawsuit. That's it. Monica's emails to Tammy Denbo aren't private communications? Resson X. Manana's claims allege that appellees communicated about him publicly on Twitter. Manana himself publicly responded to the online commentary and apologized. Oh, wait a minute. Aren't they saying that, whoa. Woo. We've got another lie. This is amazing. Another lie from their own claims. They claim that that Vic's apology came prior to any of the communications, right? They said, "Oh no, those communications all came before Vic, or before Vic was fired and stuff like that." Well, Vic's apology was before Vic was privately fired. Their statements came after Vic's apology. That's interesting. Which further prompted participation from thousands of people via Twitter and YouTube, and even led to Manana's supporters. Look at how ass mad they are about this GoFundMe. Even led to Manana's supporters donating more than $257,000 to fund his lawsuit aimed at silencing appellees. Uh-oh. I guess we got to do it again. $279,048. Thank you to Anonymous and Jordan DeGenesis. Thank you guys so much for your contributions. Look, I mean, you can't. They are so mad about this. It's bolded and in italics. That not only says, look at how it all just falls out, but it also says there are fissures because they skipped the lube. Rial and Toye specifically testified that their purpose behind these communications was to participate in Fundraising's investigation. So Funimation investigated Ron, like interviewed Ron. Did they interview Ron and Monica? Is that what happened? Is that the other among others that we got? Participate in Funimation's investigation. Share personal experiences. Except if they're lies, they're still lies. Same with the investigation. To warn the public at large about Mignana's inappropriate conduct towards women. And support each other. Rial's testimony sharing her personal experience with sexual assault and the importance of participating in Funimation's investigation and corroborating other women's stories. Oh my God, they summarized their own citation. Ugh. Toye believes accounts to be true based on personal knowledge of women he knows and accounts online and Mignana's own statements. Okay, sure. All right. Brian Duig says, hey, Nick, first time super chat. Hey, thanks, Brian. If Ron and Monica lose, will they have grounds for a lawsuit against their lawyers? No. I mean, they may do it, but no. It's really hard to sue your lawyer just because they lose. If you could sue a lawyer every time they lost, half of all lawyers would be out of business immediately. Okay, so we've got, therefore, even the most stringent reading of the TCPA requires applying the statute to Mignana's lawsuit because the communications involve public participation about a sexual predator who harasses women all across the country. See what they're doing with this brief? What are they trying to do? Right? Be assholes. That's the entire job of Hellberg. Hellberg and Rusty O'Kane and Lemons, who's pretending that he's not doing this. It's just to be assholes. Pursue the defamation and further defame Vic. Claims involving conspiracy, moreover, necessarily invoke the right of association because they are dependent upon communications among members of a purported enterprise for a common purpose. Oh, you noticed that too, huh? Discussions used to support conspiracy claim clearly fall under the right of association as they were communications between individuals who joined together collectively, express, promote, pursue, or defend common interests. I thought he didn't ever bring forth any evidence of it. Mignana's claims implicate appellee's right of free speech. Dallas Court of Appeals recently addressed a similar issue and found that communications like the ones at issue here implicate the right of free speech. In Bax versus Misco, like here, the communications involve child safety and were discussed on a public internet forum. By stating her strong suspicion that someone suffered from MBPS, Johns indicated a child was suffering abuse from a parent. Thus, John's statement not only involved a matter of someone's health, but also a child's safety. Because John's statement related to health or safety, it simply fell within the statutory definition of matter of public concern. So that's it, guys. Apparently, we can all say that that Ron is a crazy pedo. I'm just kidding, obviously. But by their logic, we can all say that because by saying he's crazy, it's his health. And by saying he's a pedo, he's a danger to children. Now it's a matter of public concern. That's it. Shit statute. Really, really a bad statute. Here, unlike Pickens and Weisenhunt, the post was not on someone's personal blog or contained in private emails between individuals, but rather written in a public internet forum frequently visited by others. Post invited responses and in fact garnered both positive and negative replies. It received 1,255 views and 126 responses, 17 of which are in the record. Okay. Setting aside the obvious fact that Mignogna sued Rial and Toye over public internet comments, Mignogna's specific, and private text messages. Don't forget that. Also, private communications with Tammy Denbo. Mignogna specifically alleges that they publicly communicated about his abuse of minors and women, stating that Rial liked and retweeted Hanlea's tweet that accused Mignogna of being a rude asshole who's been creepy to underage female fans for over 10 years. Liked and retweeted a statement accusing Monica of great volumes of sexual misconduct. Retweeted another statement urging Funimation to reconsider hiring Vic Mignogna as a voice actor in the future. It's not nice of them to go ahead and include all of these things that they did. Because now the appeals court will get to ask the question, wait a minute. So he alleged this, so we're supposed to take as fact that she did all of these things? So these people were out there saying that he did all this, and then they're going to look and they're going to find out that he's denied everything and that there are no arrests, no anything, no investigations, no question marks anywhere. All right. Okay. Retweeted another statement urging Funimation to reconsider hiring Vic Mignogna as a voice actor in the future. Alleging that Toye tweeted publicly that he is down because he took advantage of girls. Affidavits attached to the anti-slap motion show that the communications were aimed at community well-being in the face of an individual. Meanwhile, Rial and Toye testified they communicated with their Twitter followers and with Funimation for the purpose of telling fans and possible conference attendees about Mignogna's sexual misconduct. With underage women and to corroborate the stories of others. Now it's per se defamatory, right? Sexual misconduct. Thanks. Now, this isn't even a Mignogna allegation. Rial and Toye testified that they communicated with their Twitter followers and with Funimation for the purpose of telling fans and possible conference attendees about Mignogna's sexual misconduct with underage women and to corroborate the stories of others. So it's now per se defamatory. According to their testimony. And they should absolutely dump word count into this. Absolutely. Catch you later, Ken. They just said it. They said what they did. If Vic says it's untrue, facts fall in favor of the plaintiff. There it is. You don't even have to show damages. They're presumed. It's right there in their own document. They've got to dump word count on this. I can't believe that they would bring this up. I can't believe they would do it. Yeah, we testified that we got together and communicated with another defendant, that we, two separate defendants, by the way, got together, had a meeting of the minds to communicate with another defendant to convince them to do the same thing, to make claims about someone's sexual misconduct, which makes it per se defamatory if it's untrue. Hammer it home. Open their mouth, shove the stake in, and drop that sledge on it. Okay. This is hyper frustrating. I hope you know. Because I can't do anything about it. Like, if this were my case and my client, I'd be doing this and typing up documents. Typing up them documents. As much as I'd just be typing. Especially with that paragraph. That would get like 1,000 words. I don't know. It'd get at least a whole page just explaining, look, they laid it out. Mignogna alleged this. They testified that. Clear and specific evidence of per se defamation and conspiracy right there. It's right there. Thank you. I would just... Mignana's pleadings, combined with evidence and affidavits properly before the trial court, show that the thrust, they like the thrust, of his allegations is that appellees communicated online about matters related to child safety, sexual harassment, and community well-being. Per se. Mignana's online apology attempts to excuse his misconduct as simply inappropriate hugging, kissing, and touching. And again, they misrepresent it. He actually says to any claims about the other things that they're absolutely false. Absolutely false. Stating that the TCPA applies to lawsuits so long as the movement statements are in connection with issues related to any of the matters of public concern listed in the statute. So their public concern argument is going to contradict heavily with their defamation argument. That's going to be great. The trial court therefore correctly found that appellees established by preponderance of the evidence that the above referenced claims are based on, relate to, or in response to appellees' exercise of the right of free speech and or right to association. There you go. Monley, I'm not going to comment on that without seeing the source of it. But I hope they're not that dumb. But, whatever. Issue 2. The trial court did not abuse its discretion by excluding evidence submitted by Mignana after the agreed upon briefing deadline in violation of Texas Rules of Civil Procedure 59 and 70. Well. Here we go. Under the TCPA, if the movement shows by a preponderance of the evidence that the legal action is based on, relates to, or is in response to the party's exercise of the right to free speech or the right to association, then the burden shifts to the non-movement, Mignana, to establish a prima facie case for each essential element of the claim in question through clear and specific evidence. Mignana failed to meet his burden because his evidence was properly excluded, and in the alternative, did not provide clear and specific evidence to support the elements of his claims. This, again, all three of them have gone ahead and said the reason his claim was dismissed is because his evidence was excluded. Okay. Not that it wasn't presented, not that he didn't bring it, but that it was excluded. Now, they do argue in the alternative that the clear and specific evidence wasn't brought. But they really need this exclusion. That's their first and primary argument, that it was proper. Again, you're just telling the appeals court, you got to look at that evidence. Oh, hold on. Let's see. He says, okay, here we go. This will be interesting. Fantasy soft entertainment. We'll take a quick pause from the documents. And I'm sorry to do this, guys, but reading these documents kind of pains me. There we go. Making my last official statement regarding Fantasygate tomorrow. Calling me a fraud without knowing the full details. Yeah, the Vic situation taught us nothing. Hashtag hypocrites. Even stand by to hate me even more because I'm going to take over the entertainment industry. I'm not going to forget my haters. Oh no, buddy, don't do this. This is embarrassing. Don't do this. Word of advice to some of you, lay down your false idols. Make sure you're not worshiping anyone or anything. Come on. Now, they don't threaten to expose Vic. There. Oh. You're going to stab me in the back? Me? I'm exposing everyone tomorrow. It's on like Donkey Kong. Okay. That'll be interesting. I'm sure it'll go very well for that individual. So, if you're looking for some juicy stuff from me, you probably won't find much. I think I maybe had an email. They sent me some emails. I don't know if I even responded back like a year ago. And I don't think so. The email was just asking me to promote their GoFundMe. So, I don't know. I don't know who they're going to expose, but I'm looking forward to that disaster. What is this about FantasyGate? It's Fantasy Soft Entertainment. They were a company that they're fundraising for an anime that Vic was allegedly supposed to be in, but it looks like giving them the fullest benefit of the doubt. It looks like there was a misunderstanding and that they believed they had Vic agreeing to do their show, which meant that they could use Vic to fundraise for their show. Apparently, according to Vic's Unlocked stream, that doesn't seem to be the case. He denies it. He denies that he said something like he didn't want anybody fundraising for projects in his name, that he wanted them to, whatchamacallit, have a funded project and then talk to him about it. And he liked the idea. And he liked the art and stuff, but the project wasn't ready. So, anyway. Who cares? Never tell the internet that you're going to do the big thing. Like, don't tell them you're going to do the big thing, because it's not the big thing. Whatever it is, it ain't the big thing. Let's see. Okay. Mignana's second amended petition and evidence in response to anti-slap motion were untimely, prejudicial, and unfairly surprising. In his brief, Mignana argues unpersuasively that the trial court should have considered the second amended petition and its attachment in deciding step 2 of the TCPA analysis. Now, this is interesting. Let's take just a moment and at TCPA, uncontroverted facts are assumed as true, and fact questions are resolved. Any facts that are controverted, a fact question is resolved in favor of the plaintiff. What possible surprise would there be in bringing forward a petition at the last minute? I'll wait. You don't get to controvert the facts in your TCPA motion, and even if you were able to controvert them, they would still fall in favor of the plaintiff. So surprise is really, it's a weird argument. Now, it exists, the argument of surprise exists, but it's a strange concept, right? Look, you don't really get to argue against this, and if you argue against this, we get to ignore it, because the plaintiff's argument will outweigh your counter argument. How do you surprise someone with the argument? So I don't know if they're going to spend any word count on that, but I mean, they probably will. They'll probably just point out that though there are additional paragraphs, they addressed all of the arguments in their response, in their motion to dismiss, and in their reply to the response. In his brief, Mignana argues unpersuasively, trial court should have considered second amended petition and its attachments in deciding step 2 of the TCPA analysis. As an understanding of the case's procedural history quickly and easily defeats this argument. First and foremost, this court reviews the decisions to exclude evidence under an abuse of discretion standard. A trial court's decision may only be disturbed if the decision to exclude evidence was arbitrary, unreasonable, and without reference to any guiding rules or principles. Stating that the court reviews admissions of evidence at the dispositive motion stage under an abuse of discretion standard. In this case, the scheduling agreement set Mignana's deadline to respond to the anti-slap motion to August 30th, 2019. So this is CR 1189, 88, and 89. Let me do this. Is that volume 1 then? Hold on. Three? Oh, I'm in the wrong. Here we go. Shoot. Annoying. We need to go to what? 1188 and 89. Hold on, I'm getting there. Okay, here we go. All right. Let me pull this up real quick. Just so we can see this Rule 11 agreement. It exists. What? Can I get my snipping tool? Thank you. Okay. Here's the Rule 11 agreement. I know it's kind of small text, but bear with me. Under Rule 11 of Texas Rules of Civil Procedure, this will confirm our agreement regarding scheduling matters related to defendant's motion to dismiss under Texas Citizens Participation Act. The parties agree to the following. Plaintiff will file his responses to the TCPA motions and any objections/motions to strike on or before August 30th, 2019. That's it. Now, as Mike Dunford kindly pointed out, responses to motions have actual legal meaning. Let's see. Texas Rules Civil Procedure, responses to motion. See. From motion. Let's see. Response to motion is, well, it's I mean, there's response to motion is everywhere. Okay. So this is, again, responses. It's hard to find an easy one in the Texas Rules of Civil Procedure. I guess I could pull up the actual TCPA document. Hold on. Texas Citizens Participation Act, Chapter 27, Legal Practice and Remedies Code. Okay. Here we go. Here it is. Here's the rule. A party responding to the motion to dismiss. So motion to dismiss. TCPA motion to dismiss. Party responding to the motion to dismiss shall file the response, if any, not later than 7 days before the date of the hearing on the motion to dismiss, unless otherwise provided by the agreement by parties or in an order of the court. There's a response to a motion to dismiss is a specific thing. It's right there. This is an agreement amongst lawyers, not non-sophisticated parties. They're actually incorrect about this argument entirely. So, sorry to dwell on this. It's really, really obnoxious that they're pretending that this doesn't matter. But this matters a lot. And that's why they're arguing it so hard. It is undisputed that Mignogna did not file his response until after that deadline, holding that when Movin agreed to delay the hearing as long as the respondent filed response at least 1 week before hearing, but respondent filed response and affidavit just 1 day before hearing, trial and appellate courts erred in considering belated affidavit. Although the trial court would have been fully within its discretion to exclude Mignogna's untimely response, it granted Mignogna's request for leave to file a late response. Oh, they're talking about the 30-minute late thing. Mignogna, they didn't object to this. Mignogna told the trial court that his response was late because of technical issues. However, at least one court has equated the failure of computer equipment to the classic dog ate my homework excuse, noting that imperfect technology may make a better scapegoat from the family's dog in today's world, but not so here. This was also used in Funamations. None of them objected to the inclusion of the late documents. None of them. So they're all arguing this without actually raising the issue on appeal or before the trial court, without preserving an objection. They didn't even object to Ty's motion for inclusion. Judge Chupp ruled, and they just took it. The extent of the mistakes in Mignogna's response completely undermines the excuse that it was untimely because of technical issues. An argument, again, novel before the appeals court. Even with the extra time, though, the response is still fatally deficient. The untimely response is rife with missing citations, incomplete arguments, and other errors. More importantly, the response is based on withdrawn affidavits signed by Mignogna, Huber, and Slatosh, which were not executed in the physical presence of the notary, contrary to the notarization page signed by Mignogna's counsel, Ty Beard. Appellants moved to strike the affidavits, but rather than fight a losing argument, Mignogna voluntarily withdrew them, admitting that the affidavits were defective and did not intend for them to be considered at the TCPA hearing. Realizing that withdrawing the affidavits meant that he had almost no evidence to support his claims, Mignogna tried to bolster his untimely response by filing a second amended petition correcting those errors and filling in dozens of citations that were previously omitted. In particular, the second amended petition also sought to add unsworn declarations that were nearly identical to the withdrawn affidavits. So wait a minute. Filling in dozens of citations that were previously omitted? How would you fill in citations in a new document? That's a little weird. Also sought to add unsworn declarations that were nearly identical to the withdrawn affidavits, including the declaration of Chris Slatosh that Mignogna relies on in his brief 3 days before the TCPA hearing. Even the declarations, however, defectively failed to comply with Chapter 132 of the Texas Civil Practice and Remedies Code by not including a date of birth or address. Those are redacted. And presumably the originals have them. And they do. And they were brought to the courthouse as well. Because that's what you do with a redacted document that redacts that private information, is you then bring the original to the courthouse. Chupp didn't ask to look at it because they failed to get a ruling on any of this. Appellees objected to the admission of the new evidence and pleading, which the trial court ostensibly sustained. That's weird. The appellee's motion to strike second amended petition in response to anti-slap motion. Omnibus objections to Mignogna's TCP evidence, dismissal order excluding second amended petition and affidavits. That's not what happened at all. This is incorrect. I mean, how do you ostensibly sustain an objection? Objection, Your Honor. Oh, he ostensibly sustained it. No. Nope. Mignogna argues that the second amended petition was neither surprising nor prejudicial. However, the extent to which the second amended petition drastically altered the previous pleadings and sought to bolster Mignana's evidence contradicts that argument. But what evidence? In addition to being filed just 3 days before the September 6th hearing, second amended petition included over 34 new paragraphs of allegations, appended newly signed declarations, and attempted to shoehorn in inadmissible evidence. Declarations that are identical to the affidavits they already responded to. Attempted to shoehorn in additional inadmissible exhibits not previously included. In fact, the second amended petition included a new 7-page argument conspicuously titled prima facie evidence that's blatantly an attempt to augment the untimely response. Actually, I think it was probably there to just show how ridiculous it is. So clerk's record 24882489. I probably shouldn't bring this up. It takes too long. Where are we? Nope, too far. Da, 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 da. 2488 and 89. Yeah, this is the part that has a timeline. Plaintiff is attached to the second amended petition and to other pleadings, and to other pleadings in this case. Prima facie evidence sufficient to prove each element of each claim. Exhibit A is a timeline. Exhibit B contains multiple tweets made in response to Fundation's February 11th, 2019 tweets. Exhibit C is the unsworn declaration of Slaytosh. Exhibit D is the unsworn declaration of Huber. Exhibit E is the unsworn declaration of Vic, in which he denies the allegations made by defendants in their answers and motions to dismiss, quantifies the economic harm caused by defendants' actions, and states the non-economic damages that defendants' actions have caused him. Plaintiff's declaration is sufficient to support a rational inference that defendants knew the falsity of their statements when those statements were made, and he has suffered damages due to the defendant's tortious conduct. Exhibit F, it talks about all of these exhibits, but these exhibits are things that already existed. They're just compiled into nice things. The new stuff involves a timeline. There's some emails. Anyway, I'm reading legal documents is absurdly boring. Sorry. And I get sidetracked. I'm trying not to. How's that? Okay. Yeah, the prima facie evidence is a reminder to the court of just how much evidence actually already exists. That's the crazy thing in this. The substantive and significant additions were wholly improper, and the trial court properly excluded them, except they didn't. Holding that Texas Rule of Civil Procedure 59 precludes a party from attaching purely evidentiary matters to a pleading. In its dismissal order, the pleadings are the evidence, by the way. So even if they dismiss the attachments, putting them in the pleadings makes them evidence, and they're referenced in the pleadings. They're just added as they're attached to the pleadings as appendixes or additional. What do they call them? Exhibits. They're attached as exhibits, but they're referenced clearly in the pleadings all over the place. But anyway, we'll move on. We'll move on. Oh my goodness. In its dismissal order, the trial court was clear. Notice they've got to try and argue that the order was clear and unambiguous, that it did not consider the affidavits because they were withdrawn. The court also did not consider the additional evidence submitted within the second amended petition because the evidence was filed late in violation of the parties' Rule 11 agreement. This is flatly untrue. And I hope they spend time on this argument because this is really, really important. The Rule 11 agreement does not consider a pleading or additional evidence. Ugh. Sorry. I closed my thing. Where are we? Oh, dang it. Skipped it. Wasn't it 11:45? No. All right, I'm going to stop. I keep telling you guys I'm going to stop. Keep being a liar. Anyway, it doesn't just say additional evidence. It was motions to strike and objections. So there actually is no provision stating, oh yeah, you can't have evidence added. There's been no showing that the trial court abused its discretion in that regard, and the exclusion of Mignana's second amended petition and withdrawn affidavit should be upheld. The problem is that the trial court never ruled on this. That's the real problem that they have. They're arguing abuse of discretion over a ruling that doesn't exist, stating that it is not an abuse of discretion for trial courts to refuse to consider untimely affidavits opposing a motion for summary judgment. To the contrary, the trial court was guided by sound principles and authorities and was within its discretion to exclude the second amended petition evidence attached thereto. Issue 3, the trial court properly found that Mignana failed to establish by clear and specific evidence a prima facie case for each element of his claim as defamation. To avoid dismissal under TCPA, Mignana must establish by clear and specific evidence a prima facie case for each element of the claims. This means Mignana must do more than simply provide notice. He must prove the claims by providing detailed evidence to show the factual basis for them. To maintain a defamation cause of action, the appellant must prove that the defendant published a statement, was defamatory concerning the appellant, while acting either with actual malice if the appellant was a public figure or negligence if the appellant was a private individual regarding the truth of the statement. To be defamatory, the statement must be materially false. The statement is not actionable unless it asserts an objectively verifiable fact rather than an opinion. Indefinite or ambiguous individual judgments that rest solely in the eyes of the beholder, and loose and figurative terms employed as metaphors or hyperbole are non-actionable expressions of opinion. Mignana's defamation claims are fatally defective for failure to include the complete context of the alleged defamatory statements. So here they're going to argue that you have to include every single response. By the way, these people bitched about a 1,000-page filing. You show every single response and every single thread leading up to every alleged defamatory tweet, and that filing would have been 30,000 pages of Twitter posts. Think about that. That's what they're going to argue right now. This would be great. As a preliminary matter, Mignana's defamation claims fail because he failed to or refused to provide the full context of the allegedly defamatory statements, relying instead on baseless speculation. Mignana's defamation claims are also based on libel, which requires the court to examine the entire publication and determine as a matter of law whether the statement is merely an opinion or actionable defamation. They're mincing words here, but the entire publication is the entirety of the statement made by the defendant, not every single thing on Twitter. We cannot say as a matter of law that the word abusive is defamatory per se without knowing the context of the statement. Williams, however, provided none to the trial court, but without providing the context of the statements, there's no basis in this case for the trial court to conclude that the statements were defamatory per se. Mignana's evidence of Rial or Toye's tweets suffer the same defect. They're intentionally out of context and do not constitute defamation. No, they're complete statements. They provide the entire tweet, a screenshot of the entire tweet. There's not some part of the tweet that's redacted. While Toye is alleged to have posted hundreds of negative tweets about Mignana, the context of a Twitter war context is critical. Twitter war. It's a war. Toye's in the trenches, y'all. I'm fighting the tweet war. Look out you. Guys, seriously, look out for Charlie. Coming from the trees. I gotta tweet this out right away. Oh my god. You got me. It tweeted to me. It hit me at home. I'm not gonna... I hear the helicopters. They're coming. They're like, what are we doing? What is this? This is particularly true because the nature of the discussion gives context to the debate and meaning of these hyperbolic tweets. Hyperbolic, the ones that he says, no, I mean he's actually a predator. stating that a tweet cannot be read in isolation, but in the context of the entire discussion. In this case, the tweet was made as part of a heated internet debate. Emphasis added. Okay, courts. Okay, courts. Get ready for stacks of documents. Bigger than the courts have ever seen. The entire Twitter thread. All of it. Matthew Uzulis says, stupid layman question. Is it correct to call it trial court when it was judgment? When it was judgment, if it should go to trial? Yes, the trial court level. Trial court, appellate court, Supreme Court is Texas. So there you go. One example from Mignana's petition proves this point. He includes a screenshot of one tweet to allege that Rial defamed him by saying that he's the legal definition of harassment. This tweet, without context, fails to establish who Rial is referring to, what she is responding to, or who he is. Mignana further fails to identify whether this tweet is defamation per se or per quad, a common failure among his conclusory arguments to this court. Mignana employs the same strategy with Toye's tweets. He is down because he took advantage of girls, buddy. How about getting a grip on reality and stop harassing people? Unfortunately, for Toye, he admitted to all of these in the deposition. He admitted that he doesn't remember them, but they're all authenticated. So he doesn't get to make an argument about what they mean. Ricky1186 says, defamation argument grade F. Come on, Lemon Boy, at least try to earn the money you're stealing. If they weren't awful people, I would pity the defendants with their lawyers. Still weak argument defense. Hey, the defendants are winning. Right now, they're winning. The appeals court has to overturn it. So far, I mean, I think they spent way too much, but they got the result. If that's what they wanted, they got it. This tweet in Mignana's petition without context fails to establish who Toye is referring to or what he's replying to or who he is. Absent inappropriate context, the court cannot determine if these statements are defamatory, much less whether they meet the standards for defamation per se or per quad. I love that they just picked this one out of the whole thing. So that's good. Even accepting as true that they refer to Mignana, these tweets came during a heated internet debate. Rather than include the context of the tweets, Mignana routinely selects certain excerpts out of context and merely concludes that the statements are defamatory. Over the next week or so, Toye tweeted evidence. He has been fired. There was an investigation. These actions have corroborated testimony. Their Funimation's decision was on things that happened to Funimation employees. And let's see who walks away a registered sex offender. Yeah, include all of them. Keep including them for the appeals court to see. That'd be great. All these tweets occur after the conventions terminated Mignana, i.e. no causation. Moreover, the tweets are indefinite or ambiguous individual judgments that rest solely in the eye of the beholder. And loose and figurative terms employed as metaphors or hyperbole are non-actionable expressions of opinion. They're not metaphors or hyperbole. That's a fact question. Setting aside these issues, Toye also testified that the context of his tweets were missing. Okay, but you're telling someone, bye, have fun with the predator, can't wait for you, I assume, apology. It was supposed to be it looks like. Who are you talking about? Looks like on this one, I'm not sure on this, but I'm not sure. I don't know who or what was the previous conversation, so it could be anybody. If you were a betting man, who would you say you were talking about? I don't know. Self-serving statements by the defendants is what they're relying on now to pretend that Ron wasn't talking about Vic. But maybe that's why. If that's why they win, that would be a damn shame. Further, the untimely response was so poorly briefed that it lacked proper citation to at least 24 footnotes and impermissibly thrust upon the trial court the obligation to sift through over 1,000 pages of evidence, including one exhibit that contained 341 pages of out-of-context tweets compiled by Mignana's counsel. Mignana does the same thing with his court and the voluminous appellate record. The tweets and statements allegedly made by Rial and Toye were not only true, but also could not have harmed Mignana's already terrible reputation. So again, they include tons of pages of evidence, but they shouldn't have included the evidence because they didn't include the evidence. I don't know. It's very weird. Very weird. In addition to being the tweets and statements allegedly made by Rial and Toye were not only true, but also could not have harmed Vic Mignana's already terrible reputation. Oh, okay. In addition to being out of context, a statement cannot be defamatory unless it tends to injure a living person's reputation and thereby expose the person to public hatred, contempt, or ridicule, or financial injury, or to impeach any person's honesty, integrity, virtue, or reputation. To be clear, Mignogna concedes that the negative press independently damaged his reputation, makes no effort to show whether any alleged harm he suffered was caused by Real Toye online statements or the negative press. That's not true. Mignogna has not shown that his alleged injury was due to Appellee's statements. I mean, he alleges it flatly in every single petition, all three of them, rather than the literally hundreds of other sources publishing Mignogna's history of misconduct, including the negative press. There's ample evidence in the record from several people who corroborated the allegations leveled against Mignogna, describing similar experiences and knowledge of Mignogna's poor reputation for sexual misconduct in the anime industry. In fact, 16 individuals submitted affidavits attached to the anti-slap motion showing Mignogna's bad reputation. Hashtag no conspiracy, bro. Under such circumstances, Texas courts are clear that Mignogna is libel-proof. Citation? Oh, they have one here. SWAT versus Schiffers. Let's see. Although the three statements Sawate complains about may be false, the earlier newspaper articles and the disciplinary orders describe conduct that would have ruined Sawate's reputation prior to the publication of Schiffer's article. And the disciplinary orders? These actions and others were reported in the numerous newspaper articles that were included in the defendant's summary judgment evidence. While we need not include all of the details of the articles, let it suffice to say that Sawate has been the target of extensive negative media attention for at least 10 years. Significant or extensive negative media attention for 10 years. Now they're trying to compare this to Vic being having rumors about him for a decade. That's not significant or extensive negative media attention. So much so that it is impossible to believe Sawate's reputation could have been further damaged by the statements in Schiffer's article. Pretty big difference. Pretty big difference. Mignogna did not establish that Real Toye's communications were materially false or made with actual malice, which is fatal to his claim. Standard for defamation requires some degree of fault, which in the case of a claim by a public figure is actual malice. As noted above, Mignogna is a public figure. Accordingly, Mignogna must not only show that the allegedly defamatory statements are false, but also show that the statements are made with actual malice. To show reckless disregard, Mignogna must do more than make conclusory assertions that the appellees could not know the truth of their statements. That's weird. See. Rather, there must be sufficient evidence to permit the conclusion that the defendant in fact entertained serious doubts as to the truth of his publication. Mignogna's brief completely ignores his heightened pleading requirement to show actual malice. Instead, Mignogna's brief argues only that Vic specifically denied Monica's accusations. This is clear and specific evidence that Monica's publication was false. Monica knew her publication was false. That's because it's an accusation about a personal experience that she knew. She would know if it was false because she experienced it or didn't. Random Blaze says, Ty and crew need to go after those statements about the press articles. They're based off of false stories that have been removed after the publications. Their inclusion is self-defeating. Well, that wouldn't defeat that you'd then be arguing that they knew. In an actual malice standard, it'd be kind of troubling. You'd have to argue then that they knew that the false statements were included and just didn't do any and still relied on them. It's a weird thing. I don't think they need to really go after those that hard, in all honesty, other than to point out that Monica was one of the people making those assertions under a condition of anonymity, and that that is, that's the problem that they lied about. Her not being involved in it. But this conclusory statement is neither true nor sufficient under the law. Factual basis existed for defendant's belief plaintiff was a predator. That's for Magid. Mignogna attempts to establish Toye's actual malice by pointing out that Ronald later claimed, I know without a question he hurt people very close to me. However, there is nothing defamatory about that statement because this is true and or unverifiable opinion concerning Toye's tweets about Mignogna's assault of women. Okay. Mignogna argues only that Ronald couldn't know with 100% certainty that Vic assaulted them. As is the case with all of Mignana's allegations, he fails to show that Rial and Toye or Rial entertained serious doubts as to the truth of their statements, or even that their statements were false. Mignana deposed Toye and Rial, and yet conspicuously does not point to any testimony that would show either of them knew that their statements were false when made, or were made with reckless disregard for the truth. They should hammer on this one, because Ron says he would believe literally anything on the internet. Especially from a forum called Pretty Ugly Little Liars. They should just cite to that. That's in the record. It's in the deposition. They should clear that up. He simply concludes with no basis that he believes the statements are untrue, so it must follow that appellees knew the statements were untrue at the time they made them, which he's not saying he believes they're untrue. He's saying they are untrue, and since the appellees are making statements about matters that they claim personal knowledge of, those statements must be untrue because they can't have personal knowledge of something that didn't actually occur. So they're misrepresenting the argument, but that's their job. Appellees knew that the statements were untrue at the time they made them. Mignana, of course, provides the court with no basis for this inadequate argument. In fact, all the evidence in the record reveals that appellees did not act with actual malice and sincerely believed every word they wrote. Rial truthfully described the assault against her. There it is. That's self-defeating. That's the... This is the defeating statement right here. The assault against her. If the assault is false, then she knows it's false. Engaged truthfully in the Funimation investigation. Again, if you're truthfully relaying things, if you're asserting truth to something that you know to be false, then you know it to be false. And released her statement online because she felt it was important to corroborate other stories that were similar to hers. Wait a minute. That's a weird... Why did they include 1 and 3 here? Is it because she truthfully described the assault against her in one of those publications under anonymity? I'm genuinely asking. I don't know. Testifying about Funimation investigation, the assault that she disclosed to Denbo. Testifying that she came forward to corroborate other women's similar stories. Likewise, Toye testified about his belief in the truth of the statements. Toye deposition. Toye believes accounts to be true based on personal knowledge of women he knows and accounts online and Mignana's own statements. Toye believes Mignana is a predator based on 4 women he knows with experience in online information. Toye has personally seen inappropriate hugging of fans. Oh, for fuck's sake. I hope the appeals court runs with this. They won't, but man, inappropriate hugging of fans. The appellate record shows overwhelmingly that appellees did not make any of the allegedly defamatory statements with actual malice. Okay. Trial court properly found that Mignana failed to establish by clear and specific evidence a prima facie case for each element of his claims of tortious interference with contracts and prospective business relations. They're going to really argue heavily that the Kamehacon stuff didn't exist. State a cause of action for TI with contracts and prospective business relations. Mignana must prove each element of his claim with clear and specific evidence. Specifically, there must be a reasonable probability that the appellant had entered or would have entered into a contract. Conduct must have been independently tortious or wrongful. This is... Wait, what? These are 2 different legal standards that they've combined. This isn't part of tortious interference with contracts. They've misstated the legal standard. They should hammer on this really hard. They've misstated a legal standard to the court by combining these 2 to make it the same with prospective business relations. Defendants committed the act with conscious desire to prevent the relationship from occurring, and the defendant's interference must have been the proximate cause of the appellant's actual harm. And when the inferences with interferences with the prospective business relations, appellant must show the actions cause third persons to refuse to deal with appellant. Yeah, this is actually not correct. The tortious interference of the contract is the tortious act. That is the tortious act. It does not need to be independently tortious. It is a tortious act in and of itself. It's different in prospective business relations in that way. Mignana did not prove any actual interference. As an initial matter, Mignana completely failed to introduce a single contract or anticipated contract to support either of these claims. I mean, the Kamehacon contract is in there, or would be in there. It's attached to Slaytosh's affidavit and unsworn declaration. During the hearing on the TCPA motion to dismiss, counsel for Mignogna outright admitted that Mignogna did not present any written agreements. With respect to Kamea Khan, he relies on the withdrawn and defective affidavit from Latenight and admits that he was ultimately allowed to attend. That's not quite accurate. With regard to Kamea Khan, Mignogna admitted that he actually attended this convention under a superseding contract that he did not enter into evidence. He doesn't have to. Mignogna's entire claim for tortious interference is based on a single convention that he was not barred from attending. Like the facts in Van der Linden, not a single contracting party, actual or prospective, testified that they terminated contracts with Mignogna based on something the appellee said or did, except for Latenight. Compounding this deficiency is the fact that Mignogna refers to 2 conventions in his brief, Emerald City Comic Con and Fan Expo Orlando, that Mignogna did not even include in his petition or argue below. Not in the first amended petition, but I believe it's in the second. Mignogna's brief is significantly and fatally defective with regard to causation. Notice they wanted to gloss over that second amended petition stuff really quickly here, and especially the Latenight affidavit, and ignored the text messages as well. Mignogna's brief suffers from that age-old fallacy of post hoc ergo propter hoc, Latin for after this, therefore because of this, which assumes that simply because something occurred after an event, it was caused by the event. Temporal proximity between allegedly interfering statements and loss of contract is not enough to demonstrate causation because conjecture, guess, or speculation cannot survive clear and specific scrutiny under Chapter 27. Timing of any allegedly terminated contract standing alone is insufficient and too speculative to demonstrate causation. Proximate cause requires proof of both cause and fact and foreseeability. The test for cause and fact is whether the tortious conduct was a substantial factor in bringing about the alleged injury, that is, a factor without which the injury would not have occurred. Mignogna's evidence does not meet this standard. Mignogna's own timeline negates his claims for tortious interference and causation. In his zeal to blame appellees for the cancellations, Mignogna conveniently ignores the effect of other public factors, including the negative press, thousands of retweets of Hanleia's original. These are all fact questions that should be resolved in Vic's favor until trial. I'm not saying they will be. They should be. Thousands of retweets of Hanleia's original tweet and hundreds of online comments by people indicating that Mignogna sexually harassed women and minors. Mignogna unpersuasively suggests, this is interesting. There's not a citation for this. They don't actually cite to the record that there are hundreds of online comments that he sexually harassed women and minors. They don't quantify this. They don't provide evidence for it, and they never cite to it. They just state it. I would spend a little bit of word count here saying, you know, the appellees cite to facts not in evidence over and over about hundreds of online comments saying that he sexually harassed women and minors. These don't exist. They should absolutely do it. They never provided any of these tweets. They just have a baseless assertion that these exist. So they should maybe consider spending some word count there. Mignogna unpersuasively suggests that he lost his scheduled invitations to appear at several conventions because of appellees' communications. Raise it as a fact issue. They didn't provide any evidence for it, and he gets to win. He gets to win on that. However, at least one of the cancellations occurred before Toye's first public tweet about Mignogna. With regard to Funimation's termination, Mignogna never showed that Funimation terminated him because of what Real is alleged to have communicated. I mean, Funimation said that. Funimation flat out says it. So, yeah, I think he showed that. Talking about specifically the investigation. To the contrary, Denbo submitted an affidavit stating the decision was based on several factors, including Mignogna's interview. And Monica's. Among others. I mean, come on. They're seriously arguing that it had nothing to do with Monica's stuff. Is Vic saying, yeah, none of that's actually true? That's what got it? Okay. Weird flex. Further, at least 6 of the conventions canceled Mignogna's appearance after publication of the negative press. Mignogna's evidence is non-existent with respect to which specific appellees' alleged actions caused his purported damages. That's because he's arguing conspiracy. And he says that all of them did it. In other words, Mignogna offers no evidence that Real, Toye, or Markey were the specific reason that conventions canceled Mignogna's appearances. No, he's trying to hold you jointly and severally liable, I assume. Mignogna admits that it is not unusual at all for actors to not be invited back to a convention 2 years in a row. Mignogna failed to show whether convention's decision to not invite him was caused by Real or Toya's statements or a routine decision. It's not that they didn't invite him. They had invited. They should hammer on this too. It's not that they didn't invite him. They did invite him and then specifically uninvited him. They broke the contract. And they know this is laid out very clearly in the second amended petition. It's not as clear in the first. But again, that second amended petition will nail them if it gets in. Or it should. I guess I shouldn't say will. It should nail them if it gets in. Because it clearly alleges that all of these conventions were actual contracts or agreements that he had with people. Texas does recognize oral contracts. You don't have to have a physical paper piece memorialization of the contract. Mignogna concedes that the negative press irreparably damaged his reputation. These articles were published at least beginning on January 25th, 2019, and were themselves a reaction to public outcry concerning Mignogna's sexual harassment. Were they, though? Man, the timing on that is sure fishy, isn't it? Sure is fishy. Importantly, the sources for these articles were not appellees. They should maybe go ahead and hammer that, but rather voice actors. Appellees aren't voice actors. Cosplayers, industry professionals, convention employees, and former fans who identified and described over 100 independent allegations dating back to 2003. Mignogna simply cannot, and in fact does not even try to, separate the influence of the negative press and other online statements on his canceled convention appearances from the tweets by appellees. Fact question. Again, they need to argue these are fact questions. They're fact questions that should be properly determined by a jury. We say it was them. We say without their statements and without their involvement that this wouldn't have happened. And that's true, by the way. Specifically with regards to Monica, if no one else. Because if Monica hadn't lied to Funimation about what happened between her and Vic, then none of this happened. Period. Monica's a big instigator in this. Emphasis on big. Mignogna fails to identify any nexus between appellees and his purported damage. As with the defamation claim, Mignogna failed to offer any evidence identifying the nexus between appellees' alleged conduct and Mignogna's purported damages. And notice they're ignoring Kamehacon like the damn plague. They have to ignore Kamehacon. In Better Bus Bureau of Metro Housing Inc. versus John Moore Services, the Houston Court of Appeals held that a business's showing of declining general revenue in the wake of a negative review is not sufficient for the damages element. Oh, yeah, so Vic's Yelp review, that's what what? Texas Supreme Court also announced in S&S emergency training that evidence of damages must be sufficient to support rational inference that appellee's actions caused the appellant to lose some specific demonstrable damages. Mignogna did not attempt to explain how any damages might have been the natural, probable, and foreseeable result of appellant's alleged interference. I mean, he did, actually, with Kamehacon specifically. Dismissing claim where appellant averred that it had suffered economic harm, but did not set out specific facts showing how defendant's specific conduct caused the harm. Instead, he simply argued that he lost money from the convention cancellations. Well, I mean, defendant said thing, place canceled me, I lost money from cancellation. That's the chain, and this is a little disingenuous. Instead, he simply argued that, this is not enough. Supreme Court has instructed us a general averments of direct economic losses and lost profits, even when a dollar amount is specified, did not satisfy the minimum requirements of the TCPA. Again, shit law, an absolute shit law, stating that conclusory damage allegation does not come close to what plaintiff needed to offer to establish a prima facie case on the element of damages for tortious interference with prospective business relations. Now, they had more than that. Actually show how much he made, and then went to apply that to other conventions. But, you know, Chup didn't really care. Trial court properly found that Mignogna failed to establish by clear and specific evidence prima facie case for each element of his claim of civil conspiracy. The elements of civil conspiracy are that two or more persons, Monica by herself, also with Rial makes more than two, or with Toya makes more than two, with an object to be accomplished, with the meeting of the minds on the object or course of action, I think they've admitted to the first three already. Commit one or more unlawful or overt acts, that would be defamation, and cause damage or injury. Oh, man. I mean, I think they've made the argument that civil conspiracy occurred. But again, they have to get an underlying tort for the civil conspiracy claim. They have to get defamation or the TI before civil conspiracy can stick. But I mean, they've made the argument that civil conspiracy occurred. They did. And they actually brought in all the defendants into that argument, including Denbo, which is weird. I think they should cram that home. The elements of civil conspiracy are that... Yeah. I just read that. Because the civil conspiracy claim is a vicarious liability theory, not an independent tort claim, the claim fails because each of the underlying tort claims fails. Here, the evidence in the record wholly undermines Mignogna's claims for defamation and TI. Consequently, no basis supports the conspiracy claim. Further, conspiracy requires that a defendant commit one or more unlawful overt acts. Here, none of the appellee's allegations were unlawful. They misstate it. They misstate the legal standard right there. By the way, defamation is unlawful, not criminal. It's unlawful. But they misstate it. Unlawful or overt acts. Unlawful or overt. One or more unlawful overt acts. Here, none of the appellee's alleged actions were unlawful. They misstated their own legal standard that they had in the same fucking paragraph. Woo! In Goldstein, the Texas Court of Appeals in Austin instructed that a conspiracy requires a meeting of the minds on the object or course of action, some mutual mental action coupled with an intent to commit the act, which results in injury. There must be a preconceived plan and unity of design and purpose. They already laid this out. They laid out their civil conspiracy claim up above. Goldstein court also explained... Goldstein? Right? Individual statements made by distinct entities are plainly insufficient for a conspiracy. But you already said that they talked about it, that they had a unified purpose in talking about these things. Here, Mignogna never showed a meeting of the minds sufficient to establish conspiracy. Now, this is fatal to Mignogna's argument. To have a meeting of the minds, you necessarily must have minds. I've met Ron. Can't conspire with that guy. In fact, Rial testified that she did not have a preconceived plan with Markey or Toye. Oh, this is bullshit. In Backy's, the Dallas Court of Appeals addressed allegedly defamatory Facebook posts and determined TCPA requires more than an inference that there was a meeting of the minds. Requires clear and specific evidence. Noting that evidence of heated discussions and mean-spirited posts did not meet the threshold of clear and specific evidence of the meeting of the minds. And they're really desperate. Again, Slaytosh's affidavit puts Monica and Ron on the same damn phone call. On the same phone call. That's a meeting of the minds. Same phone call, doing the TI and the defaming to Slaytosh. Also, you can argue pretty simply that her emails to Tammy Denbo point to a meeting of the minds with those two idiots. Even if Mignogna had presented competent evidence to support his claims, trial court could have properly granted the anti-slap motion to dismiss because appellees established by a preponderance of the evidence their affirmative defenses. Oh, yeah, under the CDA, qualified privilege, and Mignogna's previously a diminished reputation. Again, they received no ruling, and Judge Chupp struck these down by denying all other relief not specifically granted. They asked for relief on their affirmative defenses. They didn't get it. They didn't get it. Under the TCPA, even if the non-moving can make a showing of each essential element, the court still must dismiss the action if the moving party establishes by preponderance of the evidence. First and foremost, Mignogna's briefs attempts to add entirely new defamatory statements that were never the subject of any petition filed by Mignogna. The only allegedly defamatory statements that were subject to this litigation are allegedly defamatory tweets or retweets made by Rial and Toye, not, as Mignogna now would have this court believe, statements made to Slaytosh. Except those are Those are included in the second amended petition. Compare amended petition and brief. Court need only look to Mignana's amended petition to see his entire lawsuit was based on tweets. It's not really true because you're also talking about the investigation, but defendants have tweeted false defamatory statements about Vic that were published by real and read by third parties. Indeed, many of the defendants' tweets are defamatory per se. Defendants knew these statements were false and made them with negligent disregard for their truthfulness. Well, if the entire lawsuit was wrapped up in paragraph 39, that'd be wonderful, but it's not. As a reminder, Slatosh affidavit was drawn, therefore not part of the underlying record. Communications Decency Act precludes defamation because appellees are not responsible for the allegedly defamatory content. Mignana's claims are actually pleaded in the trial court below. Alleged the following instances of defamation attributable to Twitter users who are not parties to this litigation. Allegedly defamatory statement number 1. This isn't an allegedly defamatory statement, I don't believe. Well, that she retweeted it. Oh yeah, well, what's again, we haven't conclusively proven that retweets are not restatements. In fact, Judge Chupp casted doubt on this specifically in the thing. The next day, Monica liked and retweeted 2 tweets here. Because the alleged defamation is based on tweets, claim is barred under Section 230 of the Communications Decency Act. Because Mignana treats appellees as publishers of information provided by a third party. Okay, so they're saying that 230 applies to these 3, which is questionable. Because they're not platforms. Monica's as big as a platform, but she's not a platform. By its terms, 230 of CDA protects an action taken in good faith, that is, with an absence of malice. As identified below, above, neither Rial nor Toy acted with actual malice. Whew. Nixhex says, I had trouble getting to sleep last night. Then I remembered when you said that the GoFundMe must keep Lemoyne up at night and be the first thing he thinks about in the morning. I then fell asleep peacefully knowing I wasn't him. Mignana also failed to establish that statements 1 through 3 are defamatory because Mignana failed to provide the full context of the statements. That's not true. Wait a minute. These are initial tweets. These are just tweets. There is no context. That's a standalone tweet. The statements are true. Rendering it impossible for the fact finder to determine if the statements are fact or opinion. Oh, shit. Fact finders don't exist at TCPA. The statements are true or substantially true because Mignana has been creepy with underage fans, which is verified by separate affidavits and evidence. Why in your affirmative defense? I mean, they're making the argument right here that there's a fact question about objectively verifiable facts. They're right here. They're saying it. I missed your other one, Riku. Oh, yeah, I did. Sorry. Riku1186 says, what I meant by weak argument is if you look at their arguments in detail, which Chupp did not do at the hearing, their arguments fall apart. Having gone to an appeals court in a different country, they tore arguments apart. And then I feel rage when I listen to these blatant lies. We can only hope that this court does the same. But they're arguing right now that there are fact questions raised by defendants that need to be looked at. They're arguing a 230 defense. Chupp ignored that 230 defense. This is not the best course of action for them. And C, Mignana failed to provide evidence that Real's retweets meet the standard of actual malice. That's not part of a Section 230 defense, though. Alleged statement number 4. Tammy Denbo. Blah, 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 blah. So here they're saying that Monica didn't defame anybody except by tweets, except here it is. Mignana failed to establish that statement 4 is defamatory because he did not establish that it had any negative impact on his reputation. The alleged statements on statement 4 are true or substantially true. Fact question. Are protected by the qualified privilege of an investigation. Further, there is no evidence that the statements were made with actual malice, which protects them under the CDA, except that Monica created the investigation. You don't get to create an investigation to make a defamatory statement. Defamatory statement number 5. Dembo telling Vic that her investigation was a confidential matter. They just went ahead. They just went ahead and talked about how these were public statements earlier. Now they're suddenly confidential. They've talked about that. These alleged statements are not defamatory because they did not meet the specificity test. Mignogna never identifies which of the 4 identified appellees allegedly made the statement about the investigation. All of them. More than one of them. Mignogna fails to include the full context of the tweets. Therefore, it cannot be determined if it is fact or opinion. It's a conspiracy, bro. Vicarious liability. All of them. Jointly and severally liable for the stuff. Adzuma99 says, honestly, Ron reminds me of a friend I had a falling out with. Dude was also a total cuck that watched his girlfriend kiss her new boyfriend while he was living with her and did nothing about it. Mignogna fails to include full context of the tweets. These, what? Okay. Now determined if it's fact or opinion. Statements are literally true because Funimation and Rooster Teeth investigated his conduct. We actually still have no idea if Rooster Teeth did an investigation. This assumes facts, not an evidence at all. And statements about future acts are merely statements of opinion. Observations and guesses about another's intentions are not facts. They are also statements about future potential, making them not facts, but predictions. Okay, so if we say Ron will have sex with a little boy, and that makes him a pedo, that apparently, that's okay, according to them. Weird. Weird. Defamatory statement number 6. These allegations do not establish... Okay, so Ronald tweeted that over 100 women had made accusations of assault. The allegations of Vic were corroborated, and there were mountains of testimony. Funimation have proof. That's why they fired him. All of these tweets, by the way, are included in the later stuff. So all of their full context is actually there. This is all a lie. Like, I hate to be that guy, but they're all added as exhibits to the whatchamacallit. They're all added as exhibits to the deposition of Ron Toye. Every single one of them was authenticated at the courthouse, and they're all attached as exhibits. They're both part of the plaintiff's pleadings, and by nature of them being exhibits attached to the deposition, then they're also part of the defendant's pleadings. They both relied on these depositions. There's no question that all of these tweets are included in full, even if they're not fully stated in the actual pleading itself. This is dishonest. It's flat out dishonest because the full context of those tweets does exist. The full tweets are there. Now they can argue that there's more context. Fact question. But 100 women had made accusations of assault, that the allegations against Vic were corroborated, and there were mountains of testimony. Okay, those are fact questions that exist. Those are fact questions. Funimation has proof. That's why they fired him. Fact question. Objectively verifiable fact question. Also tweeted, it happened to me, and I'm one voice on a sea of many. He's hurt enough people. He's a sick man and needs help. Later that day, Jamie attempted to rebuff those questioning the veracity of Monica's posts on Twitter. All of those do exist. So that's interesting. Do not establish claim. The full context is not included, which would have clarified that these statements are hyperbolic opinion. Really? Hyperbolic opinion. Vic Mignogna sexually assaulted me by grabbing me by the arms, throwing me on the bed. That whole story, Monica, that's just hyperbolic opinion, bro. Or that they're true because Mignogna was actually investigated by Funimation and Rooster Teeth. Was he? Was he by Rooster Teeth? I don't think that's actually true. And there's no evidence that the statements were made with actual malice or that they harmed Mignogna's reputation. Barring the claim under the CDA. They're going to go with the not malicious. They haven't even established that the CDA actually applies to this. They're spending a ton of word count on the Communications Decency Act. And the reason they're doing this is very, very clear. They want Vic's team to spend a lot of time arguing about an irrelevant affirmative defense. Communications Decency Act is a pointless argument in context of this situation. They're arguing that tweets, they started with tweets made by other people, and they might have a possible argument there. Now they're arguing that their own tweets are barred by the CDA. Wait a minute. Wait a minute. That's not how the CDA has ever worked. Ever. There is no citation to support that the CDA applies to your own tweets. February 19th, Monica tweeted a lengthy post which she accused Vic of sexual harassment. Blah, 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 blah. The alleged statements do not constitute defamation. It's literally true. It was investigated by Funimation and Rooster Teeth. Are true and or substantially true because Mignogna's behavior, corroborated by multiple affidavits, is indicative of a sexual predator or otherwise hyperbolic opinion. And again, he's denied all of this. So now we have a fact question that falls in favor of Vic, and he's alleged the falsity of it, are protected by the qualified privilege arising out of an investigation. Israel testified that she made those statements for good faith reasons, which cannot constitute actual malice. Well, she just said so, bro. Good faith reasons are not the legal standard for malice, for actual malice. This has been blown apart heavily by law Twitter, right? The intent of the statement and it being malicious or not malicious doesn't constitute whether or not it's actual malice or legal malice, as it were. Legal malice is knowledge of the falsity or reckless disregard for the truth. Look, you can say a false thing about someone with all of the intent in the world to protect people for good reasons, and it can still be defamatory, right? If I say that President Trump, no, let's say Biden. If I say that President Joe Biden, I describe a murder that he did back in 1987 of a 5-year-old girl and how he was sniffing her hair at the time of the murder and all this stuff. And my intention is to keep creepy Uncle Joe away from little girls on the campaign trail. That doesn't make the story that I told not false. Like, that doesn't make it not defamatory. That would be that's a crazy standard. Well, it's not, it's not defamatory, even though it's completely false and would harm his reputation. It's not defamatory because you had a good faith reason for doing. Well, I just wanted him to stay away from sniffing little girls' hair. Okay. Appellees are entitled to dismissal of the claims based on the defense of qualified privilege. The evidence in the record also mandates this court affirm the trial's dismissal because appellees' tweets are protected by qualified privilege. Qualified privilege against defamation exists at common law when the communication is made in good faith and the author, the recipient, or a third person or one of their family members has an interest that is sufficiently affected by that communication. Communication may be conditionally privileged if it affects an important public interest. Real unquestionably made the communications in good faith. She testified that she shared her personal experience because she was cooperating with an investigation that she started and then publicized. Typically, the publicizing of a qualified communication defeats the qualified immunity. They should spend word count on that. Just a little bit. And believed it was important to corroborate other women's stories. Toya, as Rial's personal fiance, was aware of multiple allegations from victims concerning Mignogna's predatory actions. Further, the contemporaneous articles written about Mignogna, along with numerous statements by individuals online, support Tortious' opinion that Mignogna was a predator and show that his matter was a public concern. Mignogna failed to offer any evidence to overcome diminished reputation, affirmative defense. Finally, as noted above, Mignogna is libel proof not only because of the negative press, online comments, and affidavits about his reputation, but he admits there have been persistent rumors of pedophilia and sexual assault about him for years. These social media attacks have happened in the past and were dispelled, and he didn't lose any work or receive any damages from it. Chuck Huber confirming that I believe Vic utilizes his position of privilege in shameful ways in attempts to obtain sex. Thanks again, Chuck. Really helpful. Good job, buddy. Solid friend. Affidavits demonstrating the extent of Mignogna's already terrible reputation. But Chuck Huber's affidavit doesn't exist. This is the only one they will admit to existing, because it really doesn't help Vic at all. Under such circumstances, Texas courts are clear that Mignogna is liable proof and cannot establish damages. Real and Toye's issue on cross appeal. The final judgment. Okay, so they've now entered their cross appeal. Final judgment improperly awards Real and Toye attorney's fees of $100,000. Real and Toye were correctly awarded attorney's fees in defending against Mignogna's claims, including conditional appellate fees. They need to go. I still think they need to argue against these conditional appellate fees, but I don't know. Maybe they're not wanting to expend word count on it. I think now that they've raised it, they might want to. Who knows? However, the arbitrary manner in which the trial court awarded attorney's fees, coupled with appellee's uncontroverted evidence, requires the court to reverse and render an award of fees. Evidence of attorney's fees is clear, direct, and uncontroverted, is taken as true as a matter of law, especially where the opposing party had the means and opportunity of disproving the evidence but did not. Well, I mean, they objected to all sorts of block billing and stuff like that. In such instances, appellate courts will reverse a denial or minimization of attorney's fees and render judgment for attorney's fees in the amount provided. In this case, appellees proved entitlement in trial fees, except Judge Chupp doesn't agree that they did. Following table identifies the amount sought and awarded by the court. Real and Toye's counsel testified extensively to the factors identified by the Texas Supreme Court. To that end, Real and Toye's counsel analyzed and applied Rormu's by applying a billing judgment reduction as appropriate, testifying that I did that calculation on an Excel spreadsheet, tracked it, identified it by timekeeper. So if you look at the Exhibit B to my affidavit, you can see the exact reductions I made to meet the Rormu's billing discretion analysis. Blah, blah, blah. Specifically testifying about the factors identified in Rormu's and how Real and Toye complied with those requirements. Fees that should have been awarded to Real and Toye and which should be rendered by this court is broken down as follows. Real and Toye faced a more complex fact pattern than Markey and Funimation and were forced to respond to significantly more attacks. This is false. They weren't forced to respond to any attacks. Why did they face a more complex fact pattern? That's weird. Following table identifies a vast difference between the factual allegations against Real and Toye. But you defended them combined for your weird purposes. Trial court wrongly suggested that Markey's attorney was able to defend the exact same case and get the same result for $48,000. How is it wrong? Wait a minute. How's it wrong? This is funny because Chubb's dismissal was not based on them successfully arguing against every allegation. It was them successfully arguing that Vic didn't bring any evidence for any allegation. So that's not actually correct. Good job, Chubb. Not only did Real and Toye's counsel have to defend two individuals as opposed to one, but also Real and Toye were the only defendants deposed and the only defendants that answered discovery, which is why they got double. And they didn't... Never mind. We know about the discovery thing. They can't really raise it on appeal. Real and Toye also bore the brunt of bad faith litigation brought by a well-funded plaintiff bent on harassment and obstruction. That's, this is lovely, right? Real and Toye's anti-slap motion in this case is the most complex anti-slap motion that I've ever litigated before. There's also evidence showing that Real and Toye's counsel led the charge to secure 16 affidavits in support of their anti-slap motion. Comparison of the Real and Toye's time records and anti-slap motion with Markey's time records. Motion to dismiss reflects the complexity of allegations against the different defendants. In fact, the following table demonstrates the difference in work between what Ms. Real and Mr. Toye addressed and what Ms. Markey addressed. In his response to Real and Toye's request for fees, Mignogna argued that the court should apply the rates of Ty Beard and Jim Bullock, yet neither of them or any expert took the stand at November 4th evidentiary hearing to defend their rates, their legal acumen, or their qualifications to opine on reasonable fees in a TCPA case. I don't actually remember this argument at all, that they should apply the rates of Ty Beard and Jim Bullock. So I'm not sure where that's coming from. Failure to testify or offer affidavit on or billing record into evidence is legally insufficient testimony to uphold fee award. They didn't actually... This isn't how Chubb calculated their fees at all. Two, I don't even remember this argument. Let's see. Similarly, because Mignogna declined to proceed with the testimony and never offered his own expert to refute Real and Toye's fees, rendering judgment for the full amount is inappropriate. Or is appropriate. Declined to proceed with the testimony. Oh, okay. Mignogna did argue, albeit incorrectly, that block billing is not allowed under Texas law by attempting to extrapolate Rormuz and citing Barrow versus Greenville. First, the argument fails because Rormuz does not reference block billing and did not adopt or endorse a prohibition against block billing. Moreover, the lack of segregation issue limits some of the concerns articulated in block billing cases. Second, Texas courts have rejected a block billing requirement where the admitted time entries allow for meaningful review of the time spent, which I think Judge Chupp says that there isn't, but I don't remember anymore. State Farm argues that El Apple requires signing a particular number of minutes to each individual task. We cannot agree that such level of detail is required to be able to meaningfully review a fee reward. Here, Real and Toye specifically entered their billing records. Their counsel walked through the time entries, and they entered a chart identifying an appropriate reduction on time spent. Trial court offered no indication that the reduction of appellee's fees was based on block billing issues or any other rationale. Therefore, the trial court abused its discretion in disregarding Real and Toye's uncontroverted evidence. Block billing is permitted and reduction of fees by 10 to 20% is appropriate. Conclusion and prayer. Praise for the reasons stated here, and that the court affirm the trial court's decision to grant their anti-SLAPP motion, reverse and render judgment that they be awarded the full attorney's fees, plus an additional $55,000 in conditional appellate fees for briefing this court on appeal. So there you go. That's it. And then there's just some, they went ahead and included this final judgment, which is nice. Let's see. See what he says here. We're just going to read this first section. We're not going to go through all of the things. Okay, in the dismissal order, the court retained jurisdiction. Oh, no, he didn't say anything. He just, having reviewed applicable law, pleadings in this action, evidence of the parties, the arguments of counsel find the defendants herein should be awarded attorney's fees and sanctions, and final judgment should be entered in this action. Here you go. They make the following findings. See, fees to Real and Toye. Wait, Funimation, Real and Toye. Yeah, he doesn't make any argument about it at all, which is great. He also failed to give them a here's their motion to dismiss. He failed to give them a ruling. Oh my God! Self-quarantining immediately. So, anyway, I don't have much else to say on this. Let's put the GoFundMe up for the wrap up here. We're at $279,163. Thank you to Anonymous, Jason Voorhees, Aaron Williams, Chaircoon, and Christopher Fortune, and Raymond L. Griffmaster 5000, Savannah Grace Petway, Nathan Poudrier. Thank you guys for your donations. I really do appreciate it very much. We are really close to hitting that $280,000. Yeah, it'll be interesting. Of course, they're going to need to respond. I imagine with everything going on, they're going to get a significant extension on time to respond. And I hope they really do spend it on really hammering out replies to every brief and really hammering home the deficiencies in the arguments between the parties. We'll see. I don't know what they're going to do specifically. We'll just have to wait and see. Oh my goodness. Ooh. All right. Well, guys, we made it through that document. I kind of want to Minecraft myself after it. Because it was... One, it's fraught with weird errors. It's got contradictory statements. They make their own arguments in several places. And I think that's really the strength of opportunity in all of the replies, is that each of the responses did provide specific opportunities for Vic's team to use the words of the appellees to hammer home why this should go on. And they should nail him on that stuff. They really should. But that's me. So what we're going to do now is we're going to do super chats for a little bit. And then we are going to wrap up the show. I will be on Twitch. It's back to Doom Eternal tonight, which is giving me a little bit of nightmares for an hour or so. I'm really, really tired today. I actually kind of, I fell asleep watching The Wire with Lady Rackets. Oh, excuse me. I kind of zoned out at the end of the episode, and then when it finished, I passed out. Then I got up. This is before this is well in advance of the show. This is middle of the day, kind of. I got up and we put the kids to bed, and then went back and sat and watched another episode, tried to wake up. So I'm pretty wiped out, which is weird. I got good sleep last night. I don't know. I think this lockdown's weighing on me. I do not watch Empire. How dare you? How dare you? How dare you? How dare you? Hey, did that chick recover from the coof? All right, guys. So if you do peace out during the super chats, catch you later. See you tomorrow for Ethan Van Sciver. Otherwise, I'll see you on Twitch for Doom. It'll be great. Knight of Hopex says, we all know none of what Monica alleged actually happened. 1, because Vic isn't attracted to Clydesdales. 2, because it was after curfew and Farmer Johnson has her put up by 8. And 3, because people would have heard her pawing on the floorboards. Come on. Knight of Hopex says, Chucklefuck Huber. Tell me you did not chew out poor Nikki for telling us that Ron thinks you don't deserve to keep your children. Please tell me that did not happen. Are you serious right now, Charles? You cannot be the stupid. Tell me it didn't. You know, I didn't say who talked to me about what. All I said was that someone talked to me about it, and it was really stupid. Mercenary X says, well, right now I'm keeping the existential dread and the cabin fever away to avoid a song and dance like the Muppets Treasure Island by watching old reruns of Stand Up from Robin Williams. Good choices. You need crazy to beat crazy. Also, did you see the boot to the skit yet? No, I haven't watched anything today. I watched 3 minutes of YouTube today, and it had nothing to do with anything I've heard about lately. I don't even remember. Kay says, it's dawning on me the super unfair disadvantage Vic is at in appeals. Ty has to not only articulately address how Chup screwed up, but also state the case of this complicated gay anime bullshit, and Chup might just send us right back here. F. Could be. Crusader Saracen says, how hard can they latch onto the inclusion of Denbo to implicate Funimation? Is this possibly the best appeal response that Vic could have hoped for? There's some good stuff in there. There's some good stuff for Vic in there. There really is. We'll see. Kay says, even if Vic gets an equal amount of pages to respond to each of these documents, he doesn't. He gets half as much. How can he possibly state his case while also pointing out and explaining all the lies the defense is dogpiling on him in their brief? That's what lawyers get paid to do. Remember, he got up to 15,000 words to make his initial brief. And now he gets to reply to these things. So his replies are condensed. They don't need to be as voluminous as before. Akasit from Bangkok says, long time no super chat. Hey buddy, how you doing? I dipped in and out a bit lately since the relocation out from Hong Kong away from the virus. Sadly, back in Thailand where the social distancing is just as bad. So many anti-Western, anti-Second Amendment media here about the U.S. Why does Thailand have anti-Second Amendment media? That's weird. Faye says, I get the feeling that they're deliberately trying to bait Thai into arguing fees. It was doubtful he can really afford to spend any space trying to argue it with the bullshit they are pleading. The idea of them getting off the hook disgusts me. Actually, the funny thing is, Ty gets 15,000 words to respond to the cross appeal, I believe. I believe he should get 15,000 words to respond to the cross appeal on fees. So he should have ample opportunity to do that. So there you go. But I'm not, I'm not positive on that, but that's how a cross appeal is a separate appeal, typically. So he should get his own response and then they get a reply to that response. William Amyot says, wait for it. Wait for it sticker. Ryan Garcia says, once again, I'm on time and Nick is not. Wow, sorry. Yeah, I was late today. Very late. Stupid Monkey Zero says, how do you like Red's Apple Ale? Apple hard ciders are decent for the most part. There's a Stearns and Foster or something like that. I didn't like that one. I don't know that I've ever had Reds. I'll have to try it. Julian Escamilla says, hey there, boss. Julian Escamilla. Can I get a really quick rundown of what's happened with Vic, Soy Boy, and Envy Thy Name is Monica in the last few weeks? It's just appeal back and forth. That's it. There's not a lot going on. Sadly been unable to keep up. You're not missing much. There's not really a lot happening back and forth. Love your show, my man. Keep it up. Hey, thanks, buddy. Keys Dave 08, thanks for the donation. You retracted your message. Tyrannosaurus Rex says, have you seen A Stardust Chapter 1 Episode 5 yet? Yes, I have. It was great. Bad Vibe says, what does Rekieta Law and Uber drivers have in common? Both are usually late and gay. Keys Dave 08 says, any chance you and Ron collaborate on Fundraiser? I'm thinking a bare knuckle boxing match with all the proceeds going to help Vic in his case. Why would Ron agree to that? Onibushi Kabuto says, what's with that bright yellow and green shirt? It's my Brazil World Cup jersey. Did you finish your scrimmage at the Boomer soccer practice? God, I wish. I like playing soccer, man. It's been too long. I die now. I almost die standing up these days. Bloody Bumper says, my mom passed away yesterday and my family can't afford her funeral. I've DM'd you my GoFundMe on Twitter. Would you share it, please? Named Edmund B. I'll share it. When did you send it? Are you sure you sent it to me on Twitter? I'm not seeing any links. Not seeing any links. I'm not sure you sent it to me. Sorry, pal. I can't find it. Raging Golden Eagle, message deleted. Hey, buddy, I need to have you on again to talk about Blade Devil. You, DM me. We should talk about next week. I heard you're kicking just absolute ass on it, so. Ramon Franco says, Chad Dad Corona Chan edition when? We'll see. Maybe next week. Clay Early. Hey, Clay. So I'm going to be doing shrooms on Easter, the eggiest holiday of the year. Pray for me, Nick and Sherkun. Clay, you're like Keith Richards, man. I think you'll live through everything. Imotaku says, can you explain why people don't understand the difference between meeting with someone or doing something and admitting an accusation? Am I retarded? No, you're not. But I'm not sure the full context of what you're saying. Can you explain why people don't understand the difference between meeting with someone or doing something and admitting an accusation? Oh, is it because, like, when Vic says, yeah, I met up with someone that, oh man, that means he definitely tried to have sex with them or whatever? I'm not sure. Because they don't want to understand that. That's why. That's the short answer. Julian Escamilla says, TLDR, the last few weeks with Vic, Soy, and Monica. Last few weeks are very basic. Vic sent his appeal briefs, or his appeal brief in general, and then each one of them has responded, and that's it. Super Alfredo 64 says, Nick, whale ho, Monica. Did someone call me a whale? Nick, yeah, and a whoo throws a harpoon. Quacky boy, I'm Nick Rekieta, and I'm a furry fig and proud. My soul died a little bit just now. Grand Blue Cruise has been so long since I've been able to catch a stream. Missed this. Oh, hey, welcome back. I know a lot of people got burned out, got busy. Lane 20 says, New York Times versus Sullivan refers to public officials. Where do we tie in celebrities? It happened later. It did, though. Lane versus Parrish, but you mean Farris, involved a professor, opera singer who went on local TV all the time. Is there another case? Not good ones for them. Phoenix Aram says, hey, Nick, I emailed Larry Lawton about appearing on your show. If there's a follow-up, where do I direct him? Stay safe and healthy. Godspeed. Who's Larry Lawton? Who's that guy? I don't know who that is. Larry Lawton? He's an author and motivational speaker. Okay. Oh, about youth crime prevention and community policing. He's got a YouTube channel. I don't know. Refer him to my email, man. Or Twitter DMs. Either way. Blaine20 says, did they misuse literally in a legal brief? Probably. Matt Schrodinger says, in Lemon voice, every stream you make, every shot you take, every lung I break, every fee mistake, I'll be watching you. So there you go. I hope that was good for you. Malik Foxon says the only way they could be madder is if they used all caps, that bold italics. Lane 20 says italics means it's not on the page / shrug. JD Hanshauer. Hausauer. I don't know, man. Welcome to the paralegal level. I appreciate it. And he also sent, I still enjoy funny business, lol. Character holding says, sorry off topic, but the correlation with 5G and Kung Flu is because China is building it, i.e. their workers or foremen are on site spreading it. Don't trust China. Blue Crimson 217, welcome to Super Lawyer level. I appreciate it. Make sure you check out the post on the community page about joining the Discord and follow the instructions there as at the Super Lawyer level. Magnus Monk says, what Warhammer 40k book to start with? Horus Rising or Eisenhorn Xenos. I'll just make it easy. One of those two. Samurai Zenji says, I find it funny they want context on the tweets Vic's team deem as defamatory, but MoRon and others took Vic out of context to smear him. I mean, of course. Cara Papa says she never corroborated shit. That's a total lie. Rogue says if MoRon escaped this lawsuit with smoke and mirror tactics, the entire Texas-based VA scene is foobarred. No wonder Sony moved funny to California with the swiftness. Adzuma99 says, wonder what Lemoyne is going to do if all of his conslutes are mowed down by Corona-chan. Blue Crimson 217 says, here's some cash, grifter. Corona-chan stopping me from using this to get some drinks or play Magic the Gathering, so you'd better use that to anonymously donate to Vic. All of the anonymous donations are me. All of them. Boba Bickle says, I'm currently archiving all your streams in MP3 format. I'm about halfway done at the moment. Pray for my dying PC, which is a fan blowing into the case. You are a monster. A good monster in the best way for doing that. That's impressive. How are you doing that? Boag says, Johnny Depp, Amber Heard stream when? I don't know. Ryan Norris says, why do I get the impression they expect the appeals court to pay more attention to the story than the evidence and argument? That's some people's approach. Some people's approach. Genghis Khan says, so Nikki, also because they want everybody reading this to see that Vic's a predator, because their intent, Monica and Ron specifically, is to call Vic a sexual predator as much as possible in a legal document, because they are pieces of shit. Literal pieces of garbage that should be tossed away in a dumpster. Genghis Khan, so Nikki, how high do you think your blood pressure is after reading Moronica's response? I don't know. My blood pressure is weird, man. It goes down when I get annoyed. Franco Miranda says, I still don't get Chuck's statement about Vic in the affidavit and they're still friends. Only useful thing is the stuff about Funimation. It's not all that useful either. RickU1186 says, slip the knife in slowly defense to each other. Jason the Great Awakening says, wow, I caught up at 2x spaz. Nick, hilarious. Gelth Walker says, first super chat. Hey, thanks, Gelth. Welcome to the show. Yeah, me spend it on good crap. Yeah, me spend it on good crap, Nick. RGE, I read yours and addressed it. DM me, bro. Jason the Great Awakening says, shrooms would make more sense than TV right now. Bloody Bumper says, didn't realize there was a parody Twitter. Sent. Thank you. Let's see what we got here. Oh, you already did DM me. So here is the link. Look, guys, I can't, as acknowledged, can't endorse this. I don't know anything about it. But if you want to check it out and make your own decisions, here is the link to the GoFundMe for the gentleman who just lost his mother and they cannot afford the funeral. Do as you will with it. Kaio Souza says, hey, Nick, long time not watching you live since I got a new job 7 months ago here in South Florida, but I'm from Brazil. Great to see you rocking your Brazil shirt again. Can you show it to the cam? Yeah, sure. Here you go. Here you go. It's even got the, it's the authentic Nike Brazil shirt, I guess. It was from World Cup, what, 2016 or something? Anyway. Siren Jag says, Ron has stretched more kids' holes than that slow kid with the hammer and the square block. Oh. Oh. And Dan Turl says, give it to me straight. Is Vic winning or losing? Vic lost. I mean, he lost at the trial court level. And that's why we're at appeals. And now we have to see. I mean, there is no winning or losing yet at the appeals court. It's really going to be it'll be either he does win or he does lose on each issue. That's what it is. There is no like status update. There's no innings that we can follow. There's no score that's kept. It's just he'll either win or he'll lose. There you go. So, all right, guys, that's what we've got for tonight. I will see you over on Twitch in a few minutes. Thank you all for joining me. Let me get that intro going. Get that intro rocking. Not the intro. No, what intro? Outro. Oh, God, I'm so bad at this. So bad. I've been doing this for years, and I'm so bad at it. Anyway. Okay. Well, we'll see you all soon. Hopefully you have a good night. Peace. It just helps getting snug and jogging along with his glass by his side and his kids asleep tight. We'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitter. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a bow, more a Lafroig. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folks from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career.
get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law